Huh?
No.
Oh. Yes, where is the gentleman?
The Jana.
Where is he? He wanted to convince us on many proposition of law. Where is he? What is his name? Mr. Sudhanshu Sekhar Jaina.
He's also said that one. Civil suit is pending.
Ah. This is not expected. Make a pass over.
Item number 2.
So here, the order,
Where is the impugned order?
impugned order is at page 121.
100? Yes, give us 1 minute time to go through it. 120 or 21?
21. Impugned portion.
Yes. Was there any rule issued?
No,
No rule was issued?
no. This is for the first time when it was listed. This order having been passed, I am declared lordship.
The challenges meet to an order number 40.
Then the delay of 291 days.
Service affected,
No, ma'am. For the first time.
service,
The service matter, it became the contempt.
whatever. Sir, why you are delayed? Sir, you can't take advantage of your own wrong and then say, I am facing a contempt. Why you did not file the appeal within time? Even 1 day delay, you know, a right has accrued to the other side to oppose. No,
If your lordship can observe that, I can make a prayer
No.
before the contempt court.
this is not
Your
that.
lordship has been pleased.
No,
to
that
notice on the
service has
person
been
of-
affected.
Only that respect.
No,
that
sir,
I can
Anand.
make a prayer before.
In a condonation, no. No. Go there. Unless it is controlled. Oh. This is that matter, Rule 10(7).
10(7).
Yes. The argument was already over.
Yeah, it was argued by Mr. Rai. Just two page.
Rule 10(7).
Yes,
Vis-a-vis still 10(5).
10(5). And just show about
And-
two
and-
pages
and it-
that your lordship may
And
consider.
this is an exceptional case where the.
Oh, I understand. Please.
Just
Yes.
two pages subject to your lordship. That may be taken into account while dictating the order, but not
Yes.
we have no, because your lordships had on the last occasion heard it exhaustively when Mr. Rai was arguing. So your lordship.
So it's a change of counsel.
No, my lord, because of his absence, I have to do the medicines.
That this is an exceptional case where the petitioner phrased that the umpire sample should not have been tested.
So that is not the issue. Just to.
This is an exceptional case where the petitioner phrased that the
Our
umpire
justice
sample should not be tested.
have to-
We did not get into all those aspects. I'll just, my lords, to page lordships, see page 47. The incongruity in
Yes,
there
as we have
was.
seen, that
No.
is the part of SOCA.
Yes, and then
was
your,
issued to you at page 46.
yes, 47, if your lordship should see.
We
column-
find the differences.
Yes, column 7.
We have seen that.
Yes,
We
all are-
noticed that number.
Yeah, all
The
are,
number.
yes, all are more than 55 days so.
Yes.
after when the final is passed after that is at page 67 if your lordship so
Yes.
these 2 pages only.
Yes.
Again the variance comes back to my reading or less than that.
Yes.
If your lordship should see there all the 4 have been shown to be more than 55. Now it is 51.20, 55.19, 50.
This is in relation to what? What testing?
This is the
Fixed
final after this sample.
This is not a
Umpire sample.
This is not in relation to umpire.
This is umpire sample, the last one. If your lordship should read
Umpire sample.
analysis 5 numbers, though 4 were transported, 5th one was never.
So out of this, the three have been found to cross 55
No, my lord, out.
benchmark.
No, three, it is actually not 3 because there were 4 samples which were sent because one was never transported. This stack valuation was done but never transported. So 4 at page 47.
Yes.
Now they go to 5 and out of that now they come back to my own reading of 2 in 2 of the samples. And then the final order they have passed.
I could not get it.
No, my lord, the incongruity in their own tasting itself. Lord, if your lordship would see page 47.
No, sir. No, sir. The law has to be understood in that way. The law, as I understood this 10.5,
10.5.
there are 2 aspects. One is the moment you have win the mineral, it is stacked in a separate blocks. Before you transform under this act, ETS or something, whatever
Yes.
the rules, you are required to upload on the web portal. Form S has to be issued. You have to do it. They will come and make it a testing. They will make a sample. They will do 3 samples. One, they will test it. One, you can test it.
Yes.
Even
Third is get towards
in
umpire.
case any discrepancy arises. The moment the testing is done, you have accepted, then immediately they will issue you a transit permit. You start it.
Yes.
So this was absolutely followed in this case. There is no difficulty.
No difficult.
Transit permit was also issued to it. 10.7 says that even after the transit permit is issued, it does not really absorb the responsibility on the state and make a surprise visit
Inspection.
inspection. They can do it.
They can.
Even thereafter, they did. The state level committee, they came and make a surprise visit, inquiry, inspection, and they agreed drawn samples.
Yes.
Now that samples were tested, there appears to be a variance.
Incongruity. Yes.
Because they found it has been upgraded. Then they asked you to go for a umpire sample. There is already an umpire sample.
He makes a request.
So just no, sir. He is you who requested him whether you will go for umpire sample. Then he agreed. Approval of UMG was taken. It was agreed. And then the umpire sample was posted in your presence. And out of this, it appears that 2 of them have really upgraded. And they have claimed you raise the demand for a differential amount. Because if IP content is below 55, what rate?
One rate.
Above
55 to
is another.
58.
So they wanted a differential.
Yes.
So this is what they have done. On the last occasion, I think Mr. Roy argued
Yes.
that it cannot be done because the lifespan of a particular sample is a 3 months.
3 months.
Under 10.5 and 10.7 both. It is only for a 3 months you have to do it.
Do it.
Now it was admittedly done beyond 3 months. So the moment it is beyond 3 months, then this umpire sample cannot give you the correct analysis
reading.
of
Correct reading.
This is what he argued. I think nothing more,
Yes.
nothing less.
Nothing. Yes, ma'am. I just wanted to point out the incongruity in their own reading and testing also. That's all, just to add to it, subject to the law.
Ultimately, the umpire, because it says, the rule says umpire is the final authority.
So whether
There may be a variance, but
after 3 months.
3 months, before, after is a question.
Yes. That is the issue. Subject to the law. Your Lordship, sir, correctly and succinctly recited the entire case, my lord. We don't have anything else to add to it. That's why, sir, I said,
This is what the interpretation has to be
Yes.
done in this.
yes,
And incidentally, the point of acquiescence may also come. Deal with it. Make it a smooth. Make it dictate particular, take another 45 minutes to be.
no, my lord, if your Lordship, sir,
See,
give a short note, subject to, or else, my lord, since your Lordship's here, remember that
So I have already filed a notes of argument there, the revision.
revision of it. That can be also done.
Yes.
item number 2.
Yes, sir. What is this?
With orders lordship, this matter lordship.
So it is
Had
that
agreement.
that this lease deed had been registered instead of 5 years.
That is only
My
order.
lord, I have a small prayer today, my lord. My lord will call the matter next week. Lord, we're trying to locate, we find out the original auction notice of the year 2020, wherein it was for 5 years. So because then it was the Tahsildar in 2020. So my lord will call the matter next week. I will try to produce it before my lord. That original auction.
One thing is there, minimum period of 5 years, maximum of 10 years.
No, my lord, that was for specified minor years. Rule 8.
Oh, sorry,
Yes.
that is rule 8.
So here
That
we have
is
the
rule
auction
8.
notice,
Yes.
what was specified in the notice, the
Yes,
auction notice
you
is
give me
mine.
that.
Yes, my lord.
Yes.
So
It is submitted by the council of hearing. Oh, each.
Right, please, my lords. The petitioner, my lords, is a highest bidder, he is signed seller. And he,
Highest bidder. And seller.
no, he has not, since the date of the lease, which was executed on 24/8/2022, he has not operated the lease till, my lord, page 201, till 8/7/2026.
Till
8/7/2026. They executed the lease in August 2022. From September,
why you could not operate?
there was no road.
Road means?
No road. No road.
Road.
Don't have the PIR in the High
So
Court.
when you participated, you were aware that there is a road or not a road?
No, they told that there is a road.
So you did not go
That-
there
that
at the
time,
time
but
of
that time-
inspection.
No, and then they have admitted that the road was obstructed, and finally the sub-collector gives an order to remove the encroachment on the road, and finally they permit me, your lordship, page 201, annexure 21.
Yes.
They finally permit me
mining operation.
from the mining officer to the IIC and Tahsildar, intimation regarding resumption of mining operations at Olapua Brahmani Nadi, Tank Side Source. With reference to the subject cited
What do
above.
you want?
No?
So now it has been resumed.
And now it is, I still have a 1 year period left. So I have already represented to them, Mr. Korea, page 96, 97, 200, I've given them
What is
the
this?
translated version of my representations given to them. I have said that you give me a road, and also have prayed for extension of the period of lease. That your lordship would find at the translation of page 99.
Go there. Go there, Rule 64 had to be invoked.
Man, this is on the face of it.
What?
This is on the face of it.
Our view
What
is
can be
very
more
uniform.
genuine?
If there is no express provision under the.
That is right, that is right, that is
The
right.
court cannot rewrite a rule. for
No,
the-
that is right, man. They have already taken
Then
more than.
suppose if you were prevented from operating, you have suffered a loss,
Man,
you can,
no, I've already paid them more than.
you have a right to claim something else.
Security has paid them a demand also of 91. $22 lakhs have already been paid. I have not operated. Prior to
They
that,
will take care of this. 1 year you operate. And directing them to consider, take a decision, whether you will extend the period of the.
Kindly see for page 100.
page 100. Yes,
Very the defect Miller.
The defect.
Yes, Miller.
defect.
What defect, sir?
Consistency page
Oh,
100.
I can't read that.
Miller granted.
I've given the translated version now.
Where is the translated version?
I've given.
This Soirat is located in the district of Kendrapada. Miller. But the authorities of Fulbani district, Rayagada district has made parties here. Yeah? Yes, Miller. See the cost rating.
They cut and pressed. Sir, what to do, sir?
Pattamundi Kendrapada.
Collector both.
DDM Fulbani.
ADM Fulbani,
No, the DDM and.
Collector.
mining officer Fulbani.
That's a title. I'll correct
What
it.
time?
I'll correct it, man. May not be delivered, I'll make that correction. I'll make that correction. Needful when my friend is pointing out, thankful to my friend, and I'll make that correction. I'll make that. I cannot permit it to correct on record.
You can represent them also.
No, he is the lawyer for all.
Let's say representation is given to mining officer Kendrapada, but he is not a party given.
True. Mining officer Kendrapada.
District. No, Kendrapada district, I am on.
Yes, everything. Pattamundai, Tahsildar Pattamundai and
District
State
Kendrapada.
of Kannada.
District of Kendrapada.
There is only one. Tahsildar.
He is the most competent authority. Competent authority is the Kendrapada mining officer.
There.
The competent authority is the mining officer Kendrapada.
We made them a party.
Lakshmi call it next week, I'll add them. I'll add them. Put the record straight. I'll add them.
Who you have added? Tahsildar. Sorry, mining officer.
Mining officer Fulbani.
Mining officer Fulbani.
Full one. Right around your lordship's records.
Oh, that is what we are thinking.
My friend appears
for this fringe thing.
It's inadvertent.
Inadvertent.
No, it was a lapse on part of my office.
All a cut and paste or a copy paste.
It was a lapse by.
That is also hindsight of the technology.
The downside of the.
Copy paste.
Now,
This is what is done.
suggesting your lordship that
Who is the Mogalatama holder? Advocate of the Dua.
Ananya program.
Leave is granted.
Item number 4.
Yeah.
The lordship, seizure of five excavators, illegal seizure, lordship, without any authority of law. Lordship, they don't have any
Authority to seize.
lordship. The binding officer, which is not competent at all, lordship, to seize illegal doing. Lordship.
The mining officer is very much competent to seize, my lords know that.
There is a
But in any case, my lords, he had made that the
He's
petition.
very serious on
Yes, my
that.
lords. My lords, those excavators were found illegally engaging in, my lord, illegal mining. Therefore, my lords, they have been seized. It has been seized by an officer who is competent under the rules. Thereafter, my lord, the petitioner made a representation for release of the vehicles. That has been rejected by a speaking order yesterday. Maybe it has been, I do not know whether it has been communicated or not, my lord.
That's also illegal lordship.
So, Lord, now
That is so, lordship
speaking
can
order.
tell that order.
No, my
If
lord,
at all he has power to reject or not, lordship. What is his power?
my lord,
If he
they
has
made
the
a-
power to see.
No,
he has the
lordship,
power to
then
reject.
let's can we come to rules, lordship. Lord 51, lordship.
51, I know.
Lordship 51, how can you?
Seizure, that's the penalty. 51 is the
If
penalty.
at all he seizes lordship on vehicle,
I am
he can.
asking, seizure comes under the different provision. It's not a penalty.
No, lordship, I'm not in the 51, lordship, can you say what it is?
Please.
51
Yes,
says lordship.
Let us see.
Lordship 51, lordship. Whenever,
Yes, whenever any
person is
one
found,
is not extendable here. That's a punishable offense.
lordship.
No difficult.
My humble
Caesar.
my humble submission, I am not a mining owner, lordship. Only
Whatever Caesar.
only my vehicles were parked in a private land, not in operational lordship.
Then
My
It
vehicles,
is essentially a question of fact.
Yes.
If the authorities at the time of inspection found the same in operational condition,
lordship,
they can.
grateful lordship. That's
You
why I'm
are
saying,
not
lordship.
there, you are not
Lordship,
there.
if at all, lordship, if at all he is seized in the capacity of in excess of rule 51, then immediately.
I do not know whether 51 or any other.
Lordship, the lordship.
Caesar.
Seizure, under which provision, lordship, that's it. That is the only provision available under law, lordship, we can seize.
Yes, these can. Roman 2.
Roman 2, if at all he is seized, lordship, what he is doing since last 1 month? Lordship, can he kept within his custody? If law provides lordship, then I don't have any case, lordship. If it comes to conclusion, lordship, there is illegal mining and my vehicles were engaged there, then lordship, it must have been lordship referred to the lordship immediate court of jurisdiction. How can he lordship? And after 1 month is passing this order. How is competent to pass this order, lordship? That should be examined.
Yes.
There must be seizure and lordship he has to send to the judicial court. He can. No, he is not, lordship, he is passing this order after 1 month without making any reference.
Why you have made a representation?
Because of illegal seizure, I am saying, lordship, you have kept my vehicles without an authority of law and it was parked in a private land. It was never used for mining purpose, lordship. So
they must have rejected it. No, it was parked in a. It was in operational.
maybe lordship, then immediately they should have been sent to the lordship judicial court after making seizure. Where is the seizure list, lordship? This is illegal seizure.
Approach the
jurisdiction.
Lordship, if at all the case is referred to the judicial magistrate,
Also,
if at all lordship is sent,
would have won.
Yes.
That order.
How can you see problem?
There is a provision for compounding potential.
I have seen that, sir. I have seen that. This is what is there. Sub-rule 2 of rule 51 is very clear.
No.
Sorry, sub-rule 3. Roman 6 and sub-rule 3 are there. Of sub-rule 2, sub-rule 1, Roman 6 and sub-rule 3.
Well,
Yes. Why you are parked in the middle of the ground?
No, Lordship. It is parked in a private land outside any mining area, Lordship. It is only politically motivated. Lordship, kindly consider one aspect. Can this officer has authority to, Lordship, keep all these vehicles for his own pleasure for 1.5 months, Lordship? And the law says that if at all that is Lordship, is used in a Lordship illegal mining, it has to be referred to the Lordship judicial magistrate so that we can Lordship, how can what law Lordship authorizes him Lordship to keep all the vehicles for 1 and 15 months and passes an order when the matter is listing before the
You have
Supreme Court only.
That's,
approach the jurisdictional magistrate.
well, that part, my lord, what has happened after that, my lord, I don't have instructions. I'll update that.
When you are rejecting it, there should be some.
This, my lord, this is the instruction given to me. What has happened, the first page only. My lord will see what the factually what has happened on that date. So, my lord, here. No, no, not so. More than 9 kilometers, picture, but what is it? More about 3 kilometers. First page, my lord, that answers my lord's query. Why were they parked in that place? They were concealed. And those tracks, my lord, they were raw. And they led to where they were, my lord. That photograph by itself, my lord, it says many things.
Yes.
My learned senior has taken away a copy of that.
Yes, that's all.
Lordship,
Do we are dictating the order? No.
Lordship, last sentence, Lordship, I can convince Lordship. Lordship, my humble submission. Lordship, this illegal action cannot be continued.
That's speaking the sort.
No, not Lordship. Lordship, I want to Lordship, Kampalas have not properly communicated Lordship to convince the matter. Lordship, kindly see.
We are convinced or not convinced.
Lordship, the
it will be
vehicle,
reflected
as
in
per
our order.
as per their contention, Lordship, the vehicles were seized on 12/7. At the relevant time,
You have said so many a time that you have said so that
Yes.
12/7.
Lordship,
Then it is a duty under rule 51 to communicate to a jurisdictional magistrate. If they have not communicated,
Lordship,
then in that event, they cannot continue with the seizure.
Lordship.
And it is true, the point which you said.
Yeah.
What more convincing argument you want to advance?
So, Lordship, only my humble submission, had it been Lordship sent to judicial magistrate, I could have resorted to law, Lordship, and I could have refrained for release of vehicle. Because of your laches, Lordship, because the laches of this officer, with some Lordship political motivation, Lordship, not Lordship legally, Lordship, he has done, Lordship, with some pressure, Lordship, he has parked this vehicle, Lordship, with his own compound since last 1.5 months,
Are
Lordship.
you owner of the compound?
Yes, I am the owner of the vehicles, Lordship. Vehicle.
Own compound you have used?
No, Lordship, no, Lordship.
What does that compound mean?
Compartments,
Whether that land belongs to you?
no.
Have you taken it on rent?
Which land, Lordship?
Compound?
Sorry.
Where you have parked your
Lordship, with consent, Lordship. With consent.
Where is the?
Lordship, Lordship, that will be
Where is
tested.
the-
Lordship, that is not my point. If,
That is our point.
then I will answer, Lordship. Then I,
A excavator is found in existence at a particular place.
Grateful, Lordship.
Near to a sense area.
Lordship,
Let us proceed.
Lordship,
Near to a sense area,
grateful, Lordship.
not within the leased area. Let
Lead
us see.
area.
And it is found that this particular excavators are
Lordship,
in an operation.
Lordship,
Now the question is,
Yes.
that once you are parked,
Lordship.
whether it was parked in your own land.
No,
If it is parked in others' land,
Lordship.
then have you taken it on rent?
Yes, I will produce, Lordship.
What-
Yeah, if that is so, Lordship, because Lordship kindly see, case is listed, it has come up in weak list. Lordship, kindly see the situation. How this officer playing with courts, Lordship, and with people. Lordship, the court is listed in weak list. Today the matter, Thursday was matter taken up. He is passing order on Monday. Lordship, kindly see, he is passing this order on Monday, and my representation on 18/7.
So what your representation speaks about? That
I'm
the
saying
land on rent.
yes.
Is there?
No, I'm not saying in the private lands. No, I'm not right. I'm saying land. If Lordship, I can give the source, Lordship. If Lordship permits to file the reply on their filing their Lordship instruction, I can file a reply, Lordship. But my humble submission, this order could have been passed, Lordship, 19 also, Lordship. If that is a fact, what they are bringing it, Lordship's kind notice, these facts are available to them on 18th. This order could have been passed on 18/7, Lordship. Why they waited, Lordship, for 1 month and 1.5 months? And when the matter is listed, they are passing this order. This could have been passed on the very same day, Lordship. If they have illegally, they have seized my vehicles in constitutional section rule 51. 51 says, Lordship, that is not giving them pleasure to take
No. It gives them authority to compound the offense.
Yeah, I never agree. I am not agree.
All right.
Lordship,
But you said that they waited till 30 days.
Lordship,
They can wait till
Lordship, kindly see, Lordship, can the provisions compounding the offense, Lordship. Lordship, kindly come to
6.
Lordship, I am
Roman 6.
Lordship, first Lordship, Roman 5. When an offense under these rules is compounded, no proceeding or further proceeding as the case may be,
Different.
shall be
That is not guilty.
shall be initiated against the offender in respect of offense so compounded, and the offender, if in custody, shall be released forthwith. So there is a provision of arrest also, Lordship. If a person,
No, your case is not that.
I am not,
Go for compounding.
I am not compounding,
There is
Lordship.
no.
I am not ready for compounding because my vehicle was never used for illegal mining, Lordship. That I can prove in court. But why they will wait, Lordship, till 1.5 months? I will bring 2 judgments, Lordship. This law is already settled. They cannot wait for a minute also, Lordship. The Lordship is aware of a criminal law. If they are arresting, it has to be referred within 24 hours to the judicial magistrate. If at all, Lordship, it also gives them power to arrest a person, Lordship. If a person ought to have been arrested, Lordship, that must have been sent within 24 hours. But in this case, when they took up the Lordship proceeding and they resorted to Rule 51 in seizing the vehicle, so if a person is not agree,
No, how you are then prevented to go to the judicial magistrate?
I have immediately approached them. It is not.
No, for judicial magistrate to release the vehicle.
Lordship, there is no under which forum, Lordship, under
Which?
because Lordship, there must be some record of the judicial magistrate.
It is the duty of the court to ensure a report from the concerned authority. If the court would have found that there is no such thing,
That's why,
then
Lordship,
it could have been released.
that's why, Lordship, I have approached before, Lordship.
No, not in 210.
But Lordship, here
Judicial magistrate.
226 Lordship, my very limited prayer, Lordship. Can this power will continue? Can this action treated? Can
There is
it,
a
Lordship,
judicial
said to be legal?
He could have.
Lordship, if Lordship justify that tomorrow, Lordship, they will see the vehicles and they will sit years together, they will not pass any order. Lordship, every citizen will travel to court only to bring an order to call for a report whether their vehicle is sitting in accordance with law or not.
No, not all.
That's all, Lordship. Here is the glaring example. Your Lordship has let down the law. They cannot wait a moment also. Within 24 hours, they have to refer to judicial magistrate. And Lordship, kindly see, immediately I have approached 18/7. And Lordship, then also I have approached them before Lordship on 30/7. And when the matter is listed, yesterday is passing the order. So this part, Lordship, because Lordship, definitely this officer should be put to task. No, otherwise this mining activity, this illegal Lordship actions will be. So my humble submission that Lordship, if there is some documents that I will, Lordship, I will go for legal fight, Lordship. The law never authorizes this person, Lordship, to see the vehicle and Lordship to sit over the matter for months together, and he will not pass any order, and he will pass the order only when the matter is listed before any competent court. The 2 judgments are Shraddhanjali Jana and Lordship. Other 2 judgments are there, Lordship. Sorry, Lordship, that judgment. You are the law has been let down.
Will be a third judge
Lordship.
for your future.
That's it. Lordship may pass any order, Lordship only Lordship can allow.
That was saying I've given that, my lord, 503 BNSS. That also.
But can you contact with the professor or?
Let's see.
My question is,
Let's. Rule 51(3), let's look and see. Very clear. Lordship, that Lordship,
We are not,
Lordship.
we are not.
if we go simplicity on your surgeon, is it difficult, but we are doing much
Yes, sir.
of that.
Where Lordship,
So can you call?
also.
We are keeping to matter in the next week.
My lord.
This Sunday.
My lord.
If my friend will have a copy of the instruction, also I can able to answer.
That is their privileged stuff. It's not about, these are, the office of the advocate general.
That's true, Lordship. They have some matters. Lordship.
Item 5, sir.
Parik may be called next week. I need to add two documents. The missed out my documentation pursuant to the Lordship's order.
The senior counsel appearing for the minister.
Extension of the lease period under Rule 64. So there are certain 2-3 aspects that this was a successful bidder since 2021.
Under Rule 16.
Right, sure.
Within a time, if any such, that when you see one, this is just.
Let them pick.
Within 6 weeks. This is 6 months. Because the date of the communication.
Item number 7. Lordship, item 7, kindly grant me one Passover, Your Lordship.
What you said, I could not.
Your Lordship, for item 7, kindly grant me one Passover.
Why? You do it. You are the important record. You have signed the Mukaddama.
Yes, Your Lordship.
Do it. Yes. Yes, why you have taken the excess amount?
We have not taken, that is our fate. The instruction is also there. For subsequent years, see the allegation in the writ petition, that excess payment has been made for 21, 22, 22, 23 and 23, 24. So far as 24, 25 and 25, 26, there is no allegation. So those 3 years, so far as the demand is concerned, they have never raised any objection before the authority. But that is as per the
But
statute.
can you go beyond the?
No, that our case is, if your lordship may kindly see the instruction.
If they are not aware of the law, you can't charge anything more than.
No, it has not been
what is
charged.
the law.
Our case is, it has not been charged. He has paid the right amount, what has been demanded.
What?
Your lordship may kindly see 63-4. 63-2.
What?
Provision.
2016 rules.
By the affidavit.
Yes.
Counter by 2 weeks, rejoinder by 1 week, 3 weeks.
Item number 8.
Item 8 are counter affidavit ready.
That illegal seizure of vehicle is a police officer received. Now they are ready to take counter.
Counter affidavit will be filed with the direction, my lord. It is ready, my lord. In course of the day, we'll file it. And I'll also serve a copy of this.
It is submitted by the.
No, that last year an international application was filed that has been rejected.
So that
Now,
after expiry of the grace
you
period,
have to file counter to some.
12-1.
Some changes timely place. Also implemented. Counter regarding removal of iron ore from the.
12-1 GG.
Let them file.
Let them, only I have one request. I also request to my learned friends client. But they have issued me a letter on 24/7/26 to take over ex parte possession of my ores remaining in my area and also the entire. That let them not.
That will not be done. I should I will implement them. I will implement them. No, I will implement them. They will not.
My learned friend will be put to embarrassment unless that goes on record.
Because they have discussed.
That's
they
right,
will
I
come.
appreciate that.
Next week they will come. So in the
There was
middle,
a case of that somebody intervenes on the basis of.
Yes, yes. That
Say third
raising
party is right, it's not
contract,
there.
yes. Now the lease is not in force. The admitted portion is.
yes.
The
Item number 10.
Manuel, where virus of the rules are under challenge of contractual rules. Identical matters Malad was hearing. Malad had put me a query whether it's maintainable in a division bench or a single bench. And after going through our High Court, Honorable High Court rules and Chapter 15, it's maintainable before division. Malad have issued notice in similar manner. This may be tagged with that.
The number that
I'm giving a copy.
issue notice.
Item 11.
I'm not identical matters of their ID and the numbers that they may be heard.
Yes,
Item 11.
Thanks, 12.
Item number 12. Item number 12. 12.
Speech. Speech. They cannot rehabilitation certificate of the government of the year 2020. There's the evaluation sheet. That is why this person has been debarred. I have challenged that provision. Now, in 3 days back, there is a prayer.
The amendment to it, yeah.
I could not get that amendment. It will be added to some next week, 2 weeks after, because they have not.
On the film.
Item number 13.
Lord, teach me a computer short passage.
We come after 2 weeks. We can't wait.
Remember this the case, the army issue, the Narasimhas, all the cases, they have challenged the virus of the.
Item 14.
The date has been fixed.
Past September.
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 Obliged.
Item number 14.
Let me brief this, that this matter that claim to that the forfeiture is a quantity not lifted. Forfeiture of EMD to the extent quantity not lifted by the PD.
We are in the process of
Right.
12 GG. You are arguing.
As
Can it be taken up along with that?
this is the matter. The matter is very important.
Oh,
No.
so when that matter is fixed.
But this is the matter. I don't think there is any other matter. This is the matter your lordship has already done.
Today
only.
Thank
That's a
you.
today was
matter.
No, 12-1 GG is different. That 12-1 GG is different. That matter. This is that I had a contract with NMDC for lifting of my purchase order. On the basis of purchase order, say I was supposed to lift 100 metric ton or 100. I had been able to lift 50% of that. The contract says that if in case I fail to lift any quantity, the forfeiture shall be to the extent I fail to lift the quantity.
Okay.
So that's
Yes,
the
I
only
remember. Now, my brother was not.
Yes, Lord, my Lord was.
What do you see? That clause.
Yeah, I'll just point it out. That is clause 6.3, page 65.
That's why it was not
In fact, it was reserved for orders. Your Lordship was
65.
Lord, page 65, clause 6.3.
Forfeiture.
Yes, forfeiture of security deposit. Each unit will be treated as an independent contract and will be bound by the terms and conditions specified in the catalog. In case the bidder do not lift the minimum quantity, incomplete units shall forfeited.
Yes. This is for income. 1 second.
They also speak the same thing in the penalty clause, page 68. Thanks. It will be the unlimited quantity as per clause 14 will be treated to be abandoned goods. Then 14B, if the buyer fails to lift 80% of the allotted quantity, penalty shall be charged at the rate of 2% plus GST. That is there. Excluding tax and levies.
Unlifted.
Unlifted quantity calculation.
We have submitted, that also we have reiterating that even if the security deposit will be forfeited totally, not in not in ratio,
Total.
my lord, not in ratio to the incomplete amount.
Then why this 6.3 was introduced by you, sir? What is the meaning of the word incomplete units?
Yes.
What is the meaning of the word incomplete units?
That means, my lord, what I am understanding, my lord, if the unit is incomplete, then the entire.
That is what I wanted, I think, on the other day. I just wanted to ascertain the meaning of the word unit.
My lord, I had actually.
What is the unit? Unit means the total quantity or what?
The total stock.
Correct. So then incomplete means, supposing there is 100 metric ton, he has lifted 50 metric ton. Then according to you, the security deposit, apropos 50% or a 50 metric ton, you can forfeit.
That will be treated as abandoned.
But not for
the
the
whole.
entire security. That is what appears.
That was a limited case. They also considered.
My lord also hold that opinion, but our submission is
Submission must be
whatever way
must be on the basis of the language.
agreement, my lord. Only basis.
Language. Why? This is your document, sir. You have created. Why you have?
And they have accepted, my lord.
What accepted?
This is
They are-
agreement.
then why they are challenging here?
Agreement between both the parties.
Yet, this part. How can they accept? You can't go beyond the terms of the contract.
No, my lord, that we are agreeing, but we are only submitting our views, our interpretation. That for the incomplete unit means whatever items may be left. If it is plus oblique minus 10% per lot, that is the quantity tolerance. If it is less than that, for that it will be forfeited.
Where is the 10% tolerance? From where you get?
My lord, serial number 1, OFN page 59, annex 3 CWP, madam. Consolidated read person, my lord.
Page 59, Lakshmi kindly.
Page 59, my lord.
Para 1.
Para 1.
Yes.
Below that column. Below that.
Following materials are available.
Yes, following material available. I am concerned with serial number 2, 4021.58 metric ton. But just below this table, quantity tolerance is plus minus 10% per load for road transport.
What is this
These
quantity
are-
tolerance? What do you mean by quantity tolerance?
Quantity tolerance, my lord, I am understanding that
Loss.
if this 10%, either 10% less or more.
I do not know. What is this? Quantity tolerance, I do not know. Quantity, I understand. Tolerance means what?
Means that can be tolerated by the parties. So 10% less or 10%.
That is only for the road transport.
My lord, it is-
The tolerance here, once.
So the tolerance, I
Yes,
understand
tolerance
is a
here.
different
Kindly
meaning.
page
There's a different
65.
meaning.
The tolerance is magnified in page 65. Thanks. Clause 6.2. Release of security deposit. After successful lifting of minimum quantity, that is plus minus 10%, means the quantity which I have agreed to lift
Correct.
plus minus 10% as specified in the catalog by the successful bidder within the specified time. The security deposit will be released after completion of the contract period. Recollection of royalty, but this is
So according to you,
Yes.
that plus means
Huh.
if you have been awarded 100 metric
Yes.
tons, then you can also lift
90 or 110. 90 or 110, in that case, security deposit will be refunded. But so far as forfeiture is concerned, just below that, 6.3.
Okay. Now I got
And
I got it.
right. But exactly 50%, we have lifted. 2041, we have lifted.
20
Out of 4021, 0.5.
2041 you have lifted
Right.
out of
2041.040, they have lifted
0.40.
040.
040.
2041.040, they have lifted out of 4021.58.
21.5.
58, man.
5. Close. Nearly more than a 50%.
Little more than.
Little more.
Very
My lord, 1980.54 is left, man. So, lifted. 1980.54 is
I'm
left.
just saying nearly above the 50%. Just nearly above.
6.3, if your lordship would read along with page 67, 8 Roman 2, that will more clarify the page 67, para 8, mode of dispatch, Roman 2. If the successful bidder fails to lift the material within the stipulated time of the contract, the EMD and material value as per clause of abandoned goods of the concerned lot shall stand forfeited with the closing.
Abandoned goods says that
Yes.
it
Abandoned
has to be
left out.
declared as abandoned goods by virtue of the earlier clause.
Yes, Lord. Abandoned good is page 68 clause 14. The left out material will be abandoned good. And to that extent, security deposit will be 40. That is 8 Roman 2.
Yes, give it. Give it.
Yes.
I will take it. Yes.
Item number 15.
No, in fact, there are 2 amendment applications here.
What?
Amendment application. But at the time of getting ready,
Given a
first of all, there are 2. The first one we don't face it because the one which do not face it, IA number 19463 of 25, we do not face it.
Flagging.
the record so much that it does not seem to proceed with the listed application. That's straightforward.
Please.
for a week. And I will do the needful.
Valid date may be. So that's so many cases.
Yes.
Another
Item
date with the amendment.
Or next Tuesday is very.
Mine.
It will be done with justice, Governor. Don't worry about it. No one will.
Mine.
item number 17.
Last week, your Lordship was hearing this matter. I was praying for the appellate authority to be considered because appellate authority has not taken a decision on legality of the demand. Lordship, remember the petitioner was
Yes.
Yes, was argued at length by its last week.
It's annexure 5 and annexure plus.
annexed. That was the initial rejection and annexed 12 is the appellate order. Initial rejection challenge which are filed it application. Well, Lordship directed him to file the appeal, and appeal was filed. And during course of
12 is at page
94. So refer to the relevant provisions, but it's not decided the legality of the demand because my case is that the demand is totally illegal. The rule contrary to the rule. Rules categorically says that it has to be 1/4 of the total charges of the and what they did from the second highest bidder also. They demanded the entire for 5 years. They demanded at a time, and for second highest bidder, they demanded only for 1 year, 1/4 of the 1 year royalty and other charges. Anyhow, that would have been set at least because your Lordship and his legal. In 1998, Mallet quoted the rules, but did not decide the legality of the demand. So, Mallet case 98 quoted the rules and relevant portion will be is so quoted the rule 27. Page 98 Mallet.
Yes, the photo.
The relevant sub-rule under rule 27 of the assembly reproduced below for better appreciation.
Yes.
And then 7 values. If in witness of the such intention, the selected bidder shall be required to convey the acceptance of the terms and conditions to deposit the payment, which shall be in a way that shall be equivalent to 1/4 of the total amount of royalty and additional charges and amount of contribution payable to the district mineral foundation. So they demanded the entire amount, and what the appellate authority said, they also kindly
According to you, they are cutting to 1/4, not the entire.
Not this.
Your case.
Yeah.
What is your case?
Well, my case is that they demanded the entire amount, but not deposit the entire amount. They cancel my lease, cancel my bid. But they so far as rule categorically says that 1/4 of the total charges.
That is what your case is.
That is my case.
Yes.
The demand was illegal and definite. And they, so far second highest bidder concerned, immediately 7 days after, they demanded 1/4 of the that particular. But the order also have filed that document. Dear Lord. Page 52 of the agenda, madam.
Where is the earlier order of the Tahsildar cancelling?
In the rejection order, my lord, at that Annex 5, that is, what the page, page 29. This is during cycling, there is no electricity, nothing of the sort, handwritten order they have kept. Cancellation.
Yes, and where is the subsequent demand of the workforce? Where is that letter?
Page 52, my lord.
Of the teacher.
Of the agenda.
Rejoinder.
Page 52 of the agenda.
Rejoinder is that
The
page,
flag.
Flag. Okay. Leave statement. Leave statement. Leave statement. Flag is a flag code. Agenda flag code, my lord.
এটা কুড়াইলা
And it's 50.
করতে হবে আজিরে কর
My bid was cancelled on 7th May 19. So let's see what it means. Page 52 of the agenda flag code.
Where is the flag?
page 52.
52.
এনার বার্তা দিচ্ছেন একাউন্টস সাথে
Where do I get a ground that he has demanded the full amount?
That is the page 52, same matter. Page 52. Constitution, the 1/4 of the royalty and adjunct charges, that is the total.
No, that is the subsequent.
That's the, my demand, my lord, page 28, my lord, writ petition, page 28. Page 28, my lord. This is royalty 2 crore 86, let's see what it means, page 28. Royalty to 2 crore 87 lakhs, the DMF and other all additional charges, it is to 3 crore 82 lakhs, including
Why it says the balance security amount?
balance security amount, my lord, this is the set of this 87 lakhs, sorry, 8 lakh 70,000 security amount. But this is in the suit annual. They asked me total 3 crore 82 lakhs. They total for 5 years, and they are for second bidder is concerned, they asked for only 28,000. 20 lakh, 26 lakh, 28,000. That is 1/4 of the year. Because it is just for 5 years. These were for 5 years.
Volumes here. Last time मैंने कौन सा बिच्छू
When is this
That-
demand notice when is where it was issued?
Simply asking,
Yes, ma'am.
page 28 and page 52 of the reminder, please tell me what is the.
The penalty amount in all fairness, man, it's in terms of rule 51, the penalty.
Simply asking you, you have cancelled it as he did not deposit the amount.
Yes, ma'am.
Now he says that how can I deposit the amount? The rule, statutory rule said one form, you have demanded me the full. And you have demanded 1/4 from the others. Is it not a case of a clear discrimination? Is it your case?
Yes, my lord. And
No,
also,
no, don't go by our word.
no, my lord, it is my case and they said that the demand was contrary to the rule, therefore the rejection was illegal. That is the case. That is the reason why I said that since appellate authority did not consider it properly, therefore appellate for appellate authority considered.
In whose favor it has been settled is a party here?
Yes.
No, ma'am.
No, it was cancelled, my lord. Thereafter, he filed writ application for the Honorable Court. The Honorable Court allowed the writ application, and that judgment was challenged by the third bidder before the Supreme Court. And Supreme Court set aside your lordship judgment. And again, third bidder filed writ application for the Honorable Court, and third bidder also writ application, lordship disposed of writ application, directing the holding that it will be treated like prior pre-amendment rule will be applicable, and directed for reconsideration by the government. And government in meantime rejected it.
A representation, my lord.
No, contrary, no. So all this
Settled in favor of anybody.
No, it has not been. No third party has been
So
taken.
if it's to be settled right now, my lord, it has to be post amendment.
This
rules
is of
will apply.
2019.
That part is also made it very clear. In the second writ application, that is your lordship judgment, my sitting with my lord Justice Raman.
That's the demand.
That's the reason why.
That we demanded minus for with regards to execution of lease that has to be done by way of e-lottery minus in terms of the new rules minus amended rules.
Just a bullion order of 28. Where is the my order?
Yes, that is that page, fact at page 123.
123.
123. Of the writ petition, of the writ petition. And relevant is that page 147. Sorry, sorry, 147. It starts at page para 26. The implement order was simply founded upon the applicability of amended rule 23, who have its applicable to the past incident. Do not think it such a question would be of seminal importance at this stage, since authorities have not taken any plea whether the claim of different will interest the law enunciated in the because we do not feel it appropriate to make an observation or leave it to the wisdom of the authority to decide the same. Since amended rule simply cannot operate retrospectively as held herein above, the order input cannot be sustained. The same is hereby passed, etc. The competent authority directed to reconsider the issue in the light of the observation made. And this particular constitution has been rejected by the government. It did not know that right has been.
Yes, now this is staring at your face. Now, he said that you cannot apply the amended
Yeah.
rules. Paragraph 28, it says that entire matter has to be considered in the light of the.
Yes, my lords, but in this case, my lords, the bidder's representation was rejected by saying that the amended rules will be applicable, and your lordships are directed that it
No,
have a
that means,
prospective
that means
application.
all the decision has to be taken in the light of the
Yes.
rules which were there in Go.
Yes,
You
my
can't
lords,
take
but-
advantage that now new rules have come, so
but
we
my
can't
lords,
settle it.
at that time, the cancellation was carried out in terms of.
Suppose if the cancellation is found to be illegal, then if the cancellation order is found to be illegal, then will it not relate back?
Yes, my lord, a question arises here, my lords, is that if, let's say, the cancellation order of 2019 is
Correct.
quashed,
Is
then
what?
my
Then
lords,
what will happen?
then my lords, the question arises as to how the agreement would be
Now,
executed.
that is
Because
what is the
then-
question. That
then
means
I
it will be,
relapse
it will be,
limits by
then according to you, very interesting. Then it will be only a paper order, not amenable to be carried out.
But my lords, this
Only
can,
declaration that the cancellation is bad, no consequences, no relief, nothing can be granted. It will be a paper declaration. Okay.
no, my lords.
Then what?
My
What
lords,
would be the fallout? Suppose the
this
cancellation order.
cancellation was challenged twice by the petitioner, my lords, in previous writ
Now, what
petition.
you are talking, please tell me. Cancellation order is the subject matter of challenge.
Yes,
Correct? You are saying that if suppose we say the cancellation order is found to be illegal,
yes.
then what the court is supposed to do?
Because that's a.
Declare that the cancellation was bad,
Yes,
right? Then what?
that's the
Then
question
you
I'm asking.
take a plea that now new rule has come. So this declaration by the court will be only a paper
No,
declaration.
my lords, if the cancellation is, if the cancellation order is quashed, my lords, then pre-amendment rules will apply. What I'm asking myself here, my lords, the
Now,
question that I'm
that
asking is.
pre-amendment rule permits the settlement,
Yes,
so you can settle it.
if your lordship remands the matter back to the minding of.
No, I'm talking, but let us understand the law which you understood and what we perceive. Let us see.
No, my lords, it's a,
What would happen? What according to you should be
then my lords,
a
it would
consequential
be.
order?
If my lords, just like your lordships had observed in the last occasion that much water has flown, my lords, going all the way back to 2018 to quash a order which must have been challenged much earlier, my lords, and which was challenged, it would be like swimming against the currents, my lords. Because let's say the order is quashed, 2019 order is quashed, and if the lease is executed in terms of 2019, my lords, and if 5 years is applied to that lease, then it will expire anyhow, my lords, in 2026.
From the date of registration, when you're talking, you say,
Yes, but my lords, if it's registered, then
then from that day, 5 years.
my lords, that contradiction will appear, my
What
lords.
contradiction? Just tell me what.
Because we are.
Is the contradiction only the mode of settlement of this site's area? That's the only thing.
Yes, my
There is
lords.
no contradiction. Had it been that now you have taken a policy decision or a rule has come that no science areas will be settled in favor of a private individual, it will be run by the government, I can understand what you say. You are still settling it with the private individuals. But the mode of settlement has changed. Previously by inviting application, now by different mode.
Yes, my lords, but recently, my lords, your lordships had held, lease was cancelled, my lords, in 2025, January, my lords, and he had prayed for extension of that lease. But your lordships had directed that the court cannot issue a mandamus to do something which is otherwise not
Here we
envisaged
are
under
not
the
saying,
act.
we are saying that if a right has fructified, the period has not reckoned
But my lords, the
The
right,
period of lease, the question is that entitlement to have the lease deed executed or to be settled in his favor. And already settled but wanted an extension of time, two different concepts.
yes,
Second concept, we have held, no, we can't do it. But here you have not settled, you have denied his right.
but my lords, the right has not accrued, my lords, the agreement has
Why?
not been executed.
Then what you have cancelled?
The my lords,
No right to a lease deed
the
accrued.
bid, my lords, the bid has been cancelled in 2019 because he did not clear the dues and
What is the difference between a bid and the right has not accrued?
my lords, bid is simply a negotiation, my lords.
Madam, you have declared him as a successful bidder.
But that itself does
Means
not
your
rest
bid
in
was
my-
accepted, his bid was accepted subject to
Yes,
compliance of certain conditions. You put a condition which according to him is contrary to the statutory provision.
which he should have challenged at that point of time, my
I'm
lords.
asking, then you cancelled. He challenged the cancellation order that you can't cancel it because you can't demand something beyond the statutory provision. Matter is lingering on. Can the court not decide if your authority has not decided on this?
Yes, my lords, but what I'm trying to submit here, my lords, that when the petitioner had the opportunity,
You have a difficult case to argue, but still let us give you a full opportunity to argue.
no, my lords, when the petitioner had the opportunity to challenge those demand notices, he did not do it. Show cause notices were issued to him. Several notices were issued to him. It was not within his
Has he
knowledge.
not given a reply to this?
No,
That you
it was-
can't charge the full?
My lords, he even gave an undertaking that I will pay 10 lakh rupees of the demand notice, my lords, which is partly in acceptance of the demand notices which were issued against him because he gave an undertaking, my lords, that he'll pay the 10 lakhs. Further, my lords, he did not challenge the demand notices. And when time was given for him to pay the amount,
According to you, the illegality which is on the face of it is there, is gets legal because the other side did not raise enough.
but my lords, you also gave an undertaking that I will pay.
Does it, if you act contrary to the statutory provision, if you violate the statutory provision, whether by consent the statutory provision, that will confer a right on you.
No, my lords.
If
My
you
lords,
cannot charge a single penny beyond a statutory limit, if you charge it, that means it will get validated as the other side did not raise objection. I'm asking, simple question.
no, my lords.
Emanating from a constitutional provision.
No, my
So. Your statute says something, you can't charge more than this.
But my lords, even in the judgment which your lordships have relied on one of the paragraphs, your lordships had made an observation that time and again he was given the opportunity, but he did not reply, and therefore the dues kept pending against him, my lords. And even if that demand notice is remanded back, my lords, anything can be done only after that has been reconsidered. The demand notices have been reconsidered by the authorities because without clearing the dues, my lords, the agreement cannot be executed. So let those demand notices be reconsidered by the mining officer. It was anyway, those demand notices were passed by the revenue authorities. And then after that, my lords,
Demand notice?
yes,
Yes?
In accordance with rules, the
subject to the payment of the dues, my lords.
payment of dues comes in legal dues.
That means if you reconsider the demand notice, then in that event, whatever you will direct, They will pay, then
You
obviously.
have give the undertaking to pay.
I leave it to your lordship's discretion.
Do you realize what you have said? Anyhow, this. What is the date of the regional court's order?
Appellate order is
1/7/20.
21.
And you have filed the expedition in
So it's filed with petition
2026.
26, but as I said, the litigation continued up to August 25.
That was.
And also the earlier judgment also with the intervener, an intervener that is, which we stand have taken in the requisition, they have not counted it. And also, the person had to the knowledge of the after the Supreme Court judgment.
what?
Supreme Court for the Supreme, because when the second highest bidder lease was allowed, my lordship restored the lease. So with the petition was the intervener there. So that is pretty sealed. Anyhow, the lordship was also referred to the interim application, sorry, appeal pending.
You were not a party to that.
Yeah, I was not a party, but in intervention petition had filed. Supreme Court, I was not a party. So Supreme Court, I let Supreme Court part will learn much later.
Intervention application also not filed.
The Supreme Court intervention, because Supreme Court we were not aware that Supreme Court was filing. We were not aware that. And also, even the appeal authority also, the order was not communicated to.
Oh, other category.
Yes, ma'am.
The note also was on that at flat 16 motor function also there.
Three 2026.
What is that order?
That I have annexed in the order.
No, where is the order? It must be there in the file.
Yes,
23,
2026.
Order number 5. Inter-appeal call.
where is that? 23,
I have annexed my recognition paper in my
I
ID.
don't know, it is. Then he's recalling the order was passed in this appeal.
It is there.
No, yes, yes.
I do not find,
It is here.
I do not find the order.
Next.
But it must be there in the file.
Unless hard copy is there, how can there be a copy?
I do not find any order. 23 order I have. How can it be a 23 order? Because the appeal is filed in 25.
No, sir.
23/26,
23/3.
23rd March 26.
But it cannot be heard by us. Oh, no. It has to be. It has to be. Yes. Yeah. Which first portion or second portion of the order you want to recall?
First portion.
First.
Yes.
Why? Is a condonation application allowed?
So there is no such delay at all. I may be permitted to
Only- You are an appellant or you are a
respondent.
respondent?
Yes.
So you say there is no delay.
No, I am.
Oh, nil delay.
There is a delay of 484 days.
Correct?
But the court of division bench hold on 23/3/26.
Sir, it says that they were pursuing a remedy of a review. The court has considered it as a good ground for condonation, condoned the delay. Where is the difficulty?
Ma'am, they are optimal. Tell you the-
Why you want to recall?
Order number
Second
3.
portion, I can understand.
Yes. Well, order number 3 may.
Second portion of the order, I can understand because there is some restraint order which is given.
Yes.
But first portion, you said first portion you want to recall.
In this case, ma'am, your lordship allow me that.
What? What?
Yes, second person, whatever you say.
No, first portion is.
First.
Part 4. Well, actually, the read petition was disposed of on 16/7/2024. After more than 1 year, the read appeal has been filed.
Correct.
But prior to that, the appellant has filed a review application.
Correct.
The review application was filed in a delay of 370 days. For which the review was rejected.
How can it be? If after 1 year of when they filed, after 1 year means how many days?
365 days.
And then review is filed 370 days delay. I do not know.
With the review application was dismissed. Now the
Sorry?
present WA read appeal.
Well, I am unable to correlate that the days. I am unable to correlate the days.
With a delay of 484 days.
I like this.
Say that. Now you are saying. So there was a 404 days delay in preferring the appeal.
Yes.
There was a delay of 370 days in preferring the review.
Review.
Correct?
Yes.
So that is what you say. Now, this application was the allowed delay was condoned.
No, man.
In the appeal,
I like place what has happened.
not happened. We just wanted to know what is the correct step. Has it not been condoned by the court?
No, man. Why I am saying so? The court hold that there is no such thing.
What are you talking about?
The intra-court appeal, I may be permitted.
Appeal.
By mistaken of fact, application supported by an affidavit has been filed seeking delay.
Yes.
Application cannot be considered.
What my lords have expressed their opinion. What my lords have.
Actually, what happens, my lord?
However, appeal as such is filed in time.
Yes, there is no such.
Where is that? Where is that?
Okay.
I may be permitted.
Where is a report of our staff reporter? Where is the report? Where is the report of the staff reporter? No delay.
Lordship, the WA was filed by
Huh.
the appellate
Huh.
under Rule 6 of and clause 10 of the.
It says no delay.
High Court of Orissa.
About the writ appeal is trying to recall the order passed in the writ appeal.
Yes, ma'am.
Read appeal, no delay.
23rd.
The document
23rd.
is order
You
number
want
3.
to recall this order, brother.
He said that.
Our
The
staff
report
reporter
says
says no delay.
Yes.
My lord, your document payment order number 3. In order number 3, when I pointed out that in the read appeal, the appellant has filed the appeal after delay of 484 days
Hmm.
with challenging the order of review as well as the order of petition, my lord.
Correct.
So this honorable court hold that there is a delay. So in order number 3, this division bench of this honorable
It
court.
may be the appeal is restricted against in order of review.
Yes.
No, man, he has.
If it is,
the order.
maybe, then we can treat it as an appeal against the order of review. Then there is no delay.
But this,
But
yeah,
staff
when I have filed the
For review, there is a delay. What are you talking about?
approximate payment, the order dated, madam. Order number. P1 28/1/26, division bench of this honorable court directed the appellant to file the condonation of a delay petition as because there is a delay of 480%. Pursuant to that direction, the appellant has filed a petition in IA number 556 of 26. Your estimate will order dated 21/1/26. Order number 3, my.
Now, which IA has been filed?
IA number 556 of 26.
This is
filed by the appellant.
allowed on 24.
Condonation of delay of
It is allowed on 24.
Is Annex 1.
Order. Certified copy of the parent order.
Certified.
You have not, that has not been filed.
They have filed a
No.
photocopy of the order.
So that filed an application for
No.
exemption.
Any, have you filed the certified copy of the
No, I have not.
Oh,
parent order?
I have filed an application for the exemption for the fact, my lords, that the certified copy was annexed to the review petition.
So exemption.
No, exemption because I could not trace it to the court that certified copy be returned. So I have applied for another one, therefore I filed for exemption. The review was dismissed on grounds of delay. So I have challenged because the review did not merge, because it was dismissed. Therefore, I had to challenge the original order in the writ.
Then will it not be a time barred? Then will it not be a time barred?
Yeah, I immediately sent back and filed a petition.
Which is the reason, my lord, I was permitted to file an application.
Then this order per se is wrong.
Yes, that
23rd March order per se is
Right.
wrong.
meant. In the sense.
There are two. He has not taken a plea. Then now I am taking a plea.
Yes.
Whether appeal lies against the rejection of a review application. So,
Well, I
he's not taking that point. He ought to have taken that point earlier. He may have written many things he wrote, but he hide it in his belly, does not percolate or express in the court at the time of argument.
my humble submission, my lord, since I was pursuing the review.
Maybe that may be a ground for condonation, but you have to seek for condonation.
And I filed an application for condonation of delay, although my mistake in that is that I.
What is this 556? 556? Where is that?
556, my lord, is an IA to adduce or produce additional documents because I.
No, 556 has been disposed of. That's a condonation application.
556, you have prayed for condemnation of delay of
Where is-
484.
That should have been 370. My
That has not been dealt with.
That has not been dealt with because my lordship disposed of that.
Yeah, 556 is what?
556 is, my lords, the delay in filing the appeal from the
Correct.
original order.
That is.
So So that has been allowed.
That is
My
the
lord, that has been allowed. That is what he seeks to recall.
Correct.
My
Yes.
That is what I'm not asking you.
There it is 484 days delay. which has been
It should be
found to be
370 because of Article 14, because my lord, they are pursuing the remedy of.
Article 14. Then tell me where. What is Article 14? Read.
The period. My
Give. No, it's not so easy, sir. Read. Give him a limitation act. Read Article 14. Please. Give him. I do not require. Give it to him. Read Article 14, what it says. Read it loudly, sir.
Exclusion of time in proceeding bona fide in court without jurisdiction.
What does it mean?
When computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the defendant, shall be executed, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court, which from defect of jurisdiction or other cause of a like nature is unable to entertain.
Correct. So what is the important factor? Mere pursuing a remedy, you are entitled to an exemption. You have to move before a court having no jurisdiction or defect of jurisdiction.
No.
That's a head note also talks about having no jurisdiction.
Without jurisdiction.
Without jurisdiction. Review was without jurisdiction. Tell me.
No. With jurisdiction.
So can you take an advantage of 14?
Perhaps.
So why you said 14?
I was under the mistake of that. But my permission is for it. Right.
You was within jurisdiction.
review.
Huh? Competent.
Review was
Jurisdiction.
Application itself, it's for 84 days. My submission was.
Don't jump and say 14.
My nice one.
In para 10 of my petition, I have protested that no review can be challenged in a writ appeal.
What?
In para 10.
No review can be challenged in a writ appeal. What you say? Who is this? You have to be very careful when you draft the petition. What you have stated in paragraph 2 of your condonation application. Please read it. Where do I get an impression that you really took a step to challenge the order? Read paragraph 2.
The certified copy of the order dated 16/7/24 was received from the opposite party number 1. On 24/7/24, the present petitioner examined the case of the opposite party number 1 in detail.
Correct.
Since the matter was pending for some time with several writ petitions having been filed by the opposite party number 1, necessary file and offense office orders and orders of this honorable court in OGC number 1058 of 92, 6704
Several. Then
Had to be.
closely studied for taking necessary steps to implement the order.
To implement,
My lords, but we could not.
not to challenge.
My lords, we could not, because what this explanation says is we wanted to implement, but found out after necessary analysis and
Where
research
is,
that it cannot be implemented.
where is your statement?
There are.
Teller? Where is the statement which you are arguing? Show us, sir. Show me, sir. If you want to say that, where do I get it? As at least the one semblance of this. Where from we get it? Tell us.
But in the sense,
Since that you wanted to implement, but later on found that it cannot be implemented, as you are arguing. Where do I get this impression, sir?
my lords, para 3, my lords,
Please read that.
the cause of delay was also due to
No,
the fact
that
that
is the delay.
Of delay.
I'm
Yes, please, due to
that although not entitled to RSCP benefits, the BMC erroneously granted benefits claimed by the opposite party number 1 to similarly placed employees. Hence, it required close study and multiple discussions with officers at various levels to come to the conclusion that implementation of the order of the Honorable Court without bringing to light the necessary facts would tantamount to an abuse of process of law. That's the reason. So, my lords, because
so you can bring those facts, the new facts, without any pleading, having made in the single way before the single bench.
I was not given an opportunity to file a counter affidavit.
Okay.
It was dismissed allowed on the stage of admission without giving me an opportunity to do it. So I could not place the necessary facts, for which I have filed an application before my lords to allow me to adduce those documents, because there was no occasion for me to file a counter. The whole controversy, it's a very simple controversy, my lords. The petitioner and the respondent.
Sir, if it matter was so simple, then what threadbare discussions at the every level? Everybody discussed, so many officers involved.
The petitioner has.
It's a simple case.
It is.
You could have taken a decision immediately to challenge within a time.
I'll impress upon my lords what has happened. The petitioner is seeking parity with similarly placed employees.
The order has to be recalled.
My lords is seeking the only ground on which.
Where is your application
For the recall done.
for recall?
IA number 1492.
1492.
1492 flag R.
Oh, yes. Very interesting application from you also, sir. Very interesting application. What should be the ingredient to recall an order is completely absent. Completely absent.
And what you submitted is not your petition.
Recall application does not mean that merit of the original case is to be pleaded in that sense. And interesting, you say that after the review application is dismissed, he is precluded from challenging the parent order. Very interesting proposition of law. Where from you get it? Dismissal of the review tantamounts to merger of an order into a review order. Never. Why can't they challenge the parent order? Appeal is very much maintainable against the parent order. If two orders, they ought not to have done it. Anyhow, the two orders are there. Against one of the order, appeal is not the proper remedy. Suppose that does not mean that the appeal is incompetent because you have challenged both the orders. It will be restricted to one of the order where the appeal is remedy.
After taking into consideration that fact, this honorable court in 1-3 directed 28
So they have already prayed for 448 days delay.
Yes.
So they have already prayed for.
Because these are they
Allow the delay immediately, no difficulty.
Then the merit will be decided. I file my objection to the 1 to 484 which is delay.
What delay? They have taken shelter of the procedural hassles. Several writ petitions at your behest were filed.
Actually, the order in which the writ appeal challenged minor, the order dated 16/7/24, that is the order passed by the government, and when the government order was not complied with by the Cuttack Municipal Corporation, the present writ petition filed by the respondent before the single judgment. And the honorable single judge has only directed to comply the government order. And that order has been challenged by in the writ application, writ appeal minor by the corporation. That I have about in para 11 of my recall paper.
Not disclosing what the government order is and
So he has annexed minor.
whether there was any competency on part of the government to have passed that order. That order, my lords, was passed at the behest of the petitioner himself, who wanted a representation disposal before the government.
No, that is not a fact.
It is a fact.
No.
It is
Your
a fact.
document annex of 14 page 66 of the WA.
Record
Well, it's in item 19, well, with your lordship's permission, just note one thing, well, it's a 5-month-old judgment,
What?
not even the Supreme. 5-month-old judgment, not even listed in the Supreme Court in appeal by the other side, and they are treating it like a de facto stay, Malas.
Now there is a technical glitch. Tell him.
Network issue is there with Dr. Singh.
Dr. Singhvi, I think your system is getting frequently hanged.
Just give me 1 minute. Don't argue with the judge. Just give me half a
Yes. Yes. Unmute your system, Dr. Singhvi. It is not. Yes. Now it is unmuted.
Can you hear me now? Yes. Now, Malad, I'll take only 2 minutes. One is that there is an inconsequential small substitution IA 13933 of 26, 13933 of 26, which is a name change to Messrs. Tata, name change of the petitioner to
Yes.
Messrs. Tata Steel Limited, which has no connection with the case. It should be allowed, is the first point. The second point is, Malad, my first year main writ is, which is coming today before my lords, is directly covered by my lord's judgment. And there is not even an SLP listed or a date in sight as far as we are concerned.
Oh,
If your lordships were to allow this in my favor, following your lordship's judgment, my learned friend would only have to file an appeal. It is not a ground that they have not listed their appeal 4 months after your lordship's judgment, and then they say that, look, please wait, we are listing. The date of the judgment.
20th of April, 2nd April basis is the date.
They are the two short points, because every time it comes, they say we are listing, we are adjourning. And your lordship may in any case allow their IA.
Yes. What?
This may be the last time, Miller, because in the Honorable Supreme Court, all the defects are cured as per my instruction. And the copies are also sought to the cabinet petitioners, Miller. And as per my instruction, it is going to be listed shortly by end of this week even. Let's see, grant us 7 days time, Miller.
Malus, just kindly, I'm sorry to Malus labor this point. There cannot be a direct coverage of a judgment to a writ. Even the names are the same. Directly, my lord's ratio covers it. Now, what is my learned friend fearing? Assume my lords were to allow the writ in terms of the judgment. He's already in appeal against the main judgment. He will go to appeal against this also, Malus. It can't be a ground for indefinite adjournment, Malus. And please note, my lord's judgment is dated 20th April 26. We also practice in the Supreme Court, Malus. If you are at all serious about your SLP and you are arguing before the division bench in Odisha today on 18th of August, please don't at least insult everybody's intelligence by telling that you could not get it listed in Malus 4 months. Forget arguing. They've not got a stay. They've not argued, but you've not listed it also.
Because the defect has not been removed, because they are always filing with a defective.
All the defects are removed, Miller, in the meantime. And copies are also sought to the cabinet petitioners.
Who has lost the caveat?
No, we are among others, we are also in caveat. But that's not the point. My friends has to. The matter has come 4 times here.
This is not expected that every time you will. And
for my instruction is going to be listed on Friday. But simply call up this matter next week. Or next Tuesday.
So that's the last chance you wanted.
This week.
So we can't eternally wait. He's correct that if you have gone against all, then you can go against this also. That will be tagged together, and
that will get a chance.
It will be a very easy on your part to engage one counsel to argue.
Let's see, may call on this
in all the matters.
My esteemed seniors will not
So
oppose that. my lord.
they have a privilege of engaging different counsels, but you can engage only one counsel to argue.
Bob will get a chance to defend ourselves before the Honorable Supreme Court.
What?
Today, Your Lordship judgment is under challenge before the Honorable Supreme Court. Unless an SLP is carried out against Your Lordship judgment here, Lord, we will not get a chance to defend ourselves before the Honorable Supreme Court and raise a point supporting Your Lordship judgment. We will be here only. We will be here only.
No, I understand. Which application, Dr. Singhvi, you?
Malu, the IA 13933 of 2026.
Where is that IA?
Flag E.
Flag E, I am told, Malu. E is what the Lordship's file is what I am instructed.
There is no flagging here.
But there are three matters. Lordship, kindly see 23847, the first matter.
One after another. These are all independent matters, and it is mere a change of a name.
Right.
So it does not really affect any.
Nothing, but nothing.
Right,
He
nothing.
made a submission.
Advocate General has done.
Advocate General.
Yes.
It changes the name from Messrs Tata Steel Mining Limited to Messrs Tata Steel Limited. That's all.
Yeah, that's all. Okay. That's
One line, Tata Steel Mining Limited becomes Tata Steel Limited. That's all.
Where is NCLT's order?
NCLT?
Yes.
Yes.
Keep on.
Yes, give me the page. Give me the page.
33.
2036.
Page 20 to 36.
Yeah, of the IA.
How do I see it? No arrows are marked.
IA page 20, Lordship.
It is marked. It is at page 20, Malus. Page 9. It's at page 9 of the same file.
So it is
Of the IA.
a scheme of amalgamation which has been sanctioned
Yes.
by the yes.
It's page 9
It's
of
not
the
a
IA.
change of name. Dr. Singhvi, it is not a change of name. It is really an amalgamation scheme having
Yes, of course.
Yes.
But Malus, in that, for the Lordship's writ purposes, it is only the name change which matters. The rest has gone.
That's substitution. It would come.
Yes.
It would come as a substitution.
That's right. Name change.
Then not exactly will a name change. So we may
Very well. Malus, let us go on
have
semantic.
taken instruction from the
No,
department.
Dr. Singhvi is aware that under the Companies Act, change of name and the scheme of amalgamation is two
Are
different.
different. Yes.
Correct.
Let us put it. It's a change of name consequent to an amalgamation.
Amalgamation.
Yes.
That's a nice way of coinage of the expressions and the words.
That we may
Yes.
The order is at page 9.
Yes, I have seen that. Look, this is the.
Order 39 rule 1. 29, order 29.
That is what I'm saying.
Judgment
Yes.
is on order 29.
Now I got it. AIR 1997 Supreme Court page 3. I was correct. Either 87 or 97. I was of the view.
I'm grateful for just getting it.
In a week's time,
Yes. You just.
judgment.
Bajaj Auto is the same line.
Huh?
Bajaj Auto is the same line later.
Huh.
AIR 97 Supreme Court, page 3.
MCL. MCL. Yes. Justice Sunanda Bhandari ki accepted judgment.
Order 29 rule 1.
1982 Delhi. Milord, so many cases have been dismissed by our own High Court on this ground that a writ petition is not mentionable at the instance of a principal officer. There are so many judgments. I'll cite at least 10 judgments.
No, it is the company who is coming forward. It's a question of verification. Question of verification and affirmation to be done by authorized officer. That's the procedural aspect.
He wants to amend the cost title. A company cannot be represented by an employee.
Well, it is very unfortunate.
Somebody was to file.
I hope it's not his best point, Wallace. I hope my learned friend's respondent client's best point is not this. Third time, they are arguing on the amalgamation consequent name change. Third time. It's very unfair, Wallace. The state is supposed to be fair.
What is fairness? What is unfairness? That is not to be taught by Dr. Sri at this age. I know he is very fair. But the thing is that the state is asking for time, a week's time. I'll find an objection to that. Let me examine.
Last time also they
Can I not have an opportunity to go through the application? You are permitting an employee to be substituted for to represent a company, Milord. It is to be hard.
question of
All right,
So the difficulty is, that is what I perceived. I may be wrong in my impression. Because if the scheme of amalgamation has already been sanctioned by a competent court, then so far as the appellant is concerned, he loses his existence in the eye of law. It is regarded as a dead person. Then in that event, you can't continue with the proceedings in a dead person's. So on behalf, we have to correct the records. We have to bring something which is considered a live thing in eye of law.
Let me.
Have you got that judgment?
Lord, can it not be done the same thing the next week? I am here in Delhi. I don't have the record of hand on because your lordship he was developing a proposition to be represented by a principal officer. I said there are clear judgments to that effect.
No, it is a question of an authorized officer, nothing more than that.
No,
somebody authorized by a board of directors. Resolution has been taken.
Resolution is the only thing.
This is the only thing. I just simply asked that, nothing more than that.
That is correct. Should I not go through the application at least?
Let the company come on record, then only.
What is there, Milord? Let me just examine. If it is there, I'll be fair enough to say that it should be allowed.
Incidentally, Wallace, one very interesting fact. Wallace, kindly note this. Okay.
Sir, the answer is very clear in paragraph 10 of that judgment. Mr. Advocate General, the answer is very clear in 1997 judgment, absolutely, which I was talking about. That is a page.
The judgment may be absolutely correct. Let it come next week. Let me go through it.
Read this paragraph. It is absolutely clear.
Lord, let me go through it. I may be ignorant. I may be
clear, I don't understand.
I'm not going to let me go through the judgment.
Well, now just note two things. Your lordship is not being allowed to proceed with the main matter on the fourth day. Your Lordship is not allowed to proceed with the application for the third time. Your Lordship has Order 29, which itself says Principal Officer. Your Lordship has a 1997 SC page 3 judgment para 10. And most interesting, Your Lordship heard this matter at length. The writ was filed. No, Your Lordship heard a matter for weeks.
No,
The writ was
understand, I
filed, then
understand, Dr.
also,
Singh, we understand.
then also without the director. That time
No, we are
and
going to
now,
pass it.
my
We are
learned
going to
friend
pass
never
it.
took an objection. They never took an objection.
Absolutely. This is what is very clear.
They never took an
This is very
objection. The
clear.
earlier
Just
chap
a quick-
also is.
What is that?
Your Lordship may record my submission also.
Yes, we will record your
Yes.
submission.
Two judgments of our
Yes.
High Court, Mahanadi
sub item number
3 and 4.
is the same company.
Same company.
Okay, okay. 3 and 4. Yes.
Same order.
Yes. Same applications are filed.
Yes. Same application.
Yes.
Flag
Those
and
are.
flagging.
Yes. Those are also disposed of in the light of the instant order. Then.
The same order, but will be taken up next week.
Next Tuesday.
But that is likely to come next week's any day. I do not know. Your Lordship may call it on
Tuesday.
Your
Because
Milord in the tentative list. It may come next week. It may come next week. Your Lordship may call it 1 week after.
you come on that day. Let us see.
Coming and they are counting that it should not be adjourned. They are seeking accommodation. Your Lordship may grant me at least 10 days time.
We have given you 7 days time, Mr. Advocate General. We are on Tuesday. We have given it up to next Tuesday. I think Friday, Mondays, there is no difficulties. Those matter may come as the impression has been given in this regard to us.
That Supreme Court registry is not under my control. We have mentioned.
No.
That's very unfair, Malal. That's very unfair.
Why are they in a hurry?
Anyhow, yes.
Thank God.
Yes, come on next Tuesday. Any difficulty, we'll see to it.
Deeply obliged.
Yes. 20.
Item number 20.
That matter. Your Lordship, that matter where the benefit should have been given for captive consumption instead of limiting to 30 instead of 20. If you are read with that transitional provision we had argued last time. Okay, Your Lordship, I'll refresh. Your Lordships, this is China clay, which prior to 2015 was a major mineral.
Oh, yes.
And becomes minor mineral. And there's a complete finding of the department that this was used for captive consumption. The clause 8 also said that I have to beneficiate and then take it out. And they have denied it on the ground that they should have been a word captive consumption lease instead of.
No, we are not on that. The original parent act has withdrawn this provision, whereas the subsidiary provision.
And by virtue of section 60, rule 66, the transitional provision, the same benefit was also extended to those leases which on the date of that 2015 was a
major, but now become minor.
minor.
At last occasion, let's ask me point Miller, whether it was as a mercantile, it was given as a mercantile lease or captive lease. Lordship also pointed out to some documents where it can be shown that it was used for mercantile use. I have documents, Lordship kindly see like A and C. If the Lordship will permit me to highly
Nothing served on
Lordship kindly see it.
It says that if necessary, I can put it by way of an affidavit.
Yes.
Says so. Just wanted to prima facie convince us
Lordship
whether these are at all necessary to which we or of what consideration.
Yes. Lordship may see flag A document. Document must have flag A, my lord. And this is a part of the scheme, mining scheme, which is sacrosanct, my lord. Lordship may see the wordings.
Yes.
I have marked that portion, Lordship. Kindly have a glance. It is for mercantile. This document is not filed with the reproduction. We also could not file it with the council.
He says the beneficial, he says so. Without that, it cannot be done.
Beneficial plant is a washing plant. It is
That's
not
true.
for captive use. It is for mercantile use. They have to wash it. Then
What is the distinction between a mercantile use and a captive use? Mercantile use is that they can do a mining and then can sell those goods to a third party. But captive use is whatever they will mine, they will use it for their own industrial purpose.
Then Lordship,
I believe that is the distinction.
And beneficiation
So
plant
now,
is a
now you have yourself said that this kind of a China clay, it has certain, the amount of the aluminum. And therefore, in order to use China clay as China clay, you have to wash it out. And this is what they are doing it. And then they are using it for pottery purposes.
Director Lordship, see the document at flag B, Miller.
What flag B?
These are the invoices, Miller. They have
What?
sold it in the market. This is mercantile use.
No, this is a finished China clay.
Yes, Miller. They have sold it
They
in the market.
call it.
The document at flag B, Miller. These are the invoices, Miller.
They have sold it, no?
Yes, Miller.
So they can do it marketed.
That is the mercantile use, Miller.
How you were using when you were got the minor, when you got the major mineral?
Beneficiated. Beneficiated, and beneficiation itself is recognized statutorily as the captive use for a minor mineral. Their own definition says that. And with all due respect, your lordships, this is something they have never said that my use is not captive use. Their report says using it in the for beneficiation itself was considered as captive use in all their documents. And your lordships, that's the definition also. 2BD. Captive use means the entire quantity of minerals extracted from the mining lease in a mineral processing unit or a mineral beneficiation unit.
So beneficiation and how it is to be done.
Miller, beneficiation is to be done, Miller. The ore which are being extracted, Miller, these are to be washed and
So China clay is also not washed.
It is washed.
So once it includes the captive, the use includes this one, then why it will not come? Which is the section?
Rule 2(1)D of the 2016.
It is after 2016, Miller. But before 2016, Miller, it was something different. If your lordship allows me to file it with affidavit, Miller, I will come.
What was there before 2016?
Before 2016, captive use has not been defined under the original act. And your lordships, it's not like iron ore that I'll come up with a sponge unit. It is used as a very small raw material, say in a paint industry, in the rubber industry. So beneficiating is the captive use. It's ready for use as it is. That itself is the value addition.
Beneficiation with it is There is no concept of captive.
No, you know.
That they did not define the captive fumes.
No. But the interesting point is that the imbue order does not say that beneficiation is not a captive use. That is an argument developed today. So Mohindra Singh
Once
is
it is engulfed into a captive use, then it is so.
It is so. That is the reason why the clause 8 in my original lease said that you will have to beneficiate it before you can carry it out of the lease area.
Yes. What to do? The original act, whether any captive mine or a captive.
No, that's fine.
The original act.
India.
Entire exercise for me was made on this basis that beneficiation is captive use. They considered all my returns also, mining returns also.
Yes, we'll do it. That's your stand. That is say that what is the meaning of these words?
Let's see.
Let us go. Yes.
Let's see, kindly have a glance to section 12A. Six explanation.
Oh.
For the purposes of this provision, I am passing on the book.
That's amended, Your Lordship, that is no more there.
That is the 2015.
And that was when you transfer
Millard,
and anyway
when the lease
provision
was
is not applicable
when
to
the
minor.
lease was granted in 1966, Millard, that provision was there.
No, Your Lordship, that
Well, they had come in 2015.
Millard, under 12A provision, Millard, lease was extended from time to time.
No, that is what when the lease is going to expire after coming in force of this.
Was it 12 ways transfer of mineral concession?
True. I've seen that.
Here the wording is, Millard, the expression used for captive purpose shall mean the use of the
Where it is.
Millard, that is deleted. That. And if I may supply the book. So, where I have marked this.
It's for 2016. Yes.
6/5/2016 it was introduced and it was omitted in 2021.
Where I have marked.
After I left the sphere of
Understood. If that being the position, then why you have included it within the folds of the beneficiation? Why you have it in your lease deed?
Millard, lease deed is silent. The lease deed is silent.
Silent?
Yes. That's why let's see, put this question to whether it was for mercantile use or for that.
Yes.
It was also submission of my Lord Senior Fellow.
So from 2016 onward, will they not take advantage of this particular change of law?
Millard, if they take advantage of this change of law, Millard, then under OMMC rule 2016, the maximum period is 5 years, Millard. What is done here, Miller, if the come
So
under the
according to
category,
you, very interesting argument. Then according to you, emergency rule does not apply. Because these are the leases much prior to this. Whatever the amendment which has been brought will never come in operation so far as his lease is concerned. Do you want to suggest this proposition
No,
of
it
yours?
is- no, I don't
So
so.
that is what you are trying to say.
Here, it
Now the question is that what? Suppose at the time of the lease, let us see, at the time of the lease, there is a big act which say that on each wastage which they will do, they have to pay say around 100 rupees per metric under a particular act. Say there is an act of wastage disposal act or whatever. The lease also contains that they have to pay 100 rupees under the waste disposal act. Subsequently, that act has been repealed. Will they continue to pay 100 rupees under the waste disposal act because the lease was done at the time when this was there? They cannot deny, they have to pay off the change of law.
It cannot.
If it goes to the benefit, now it may be that at one point of time it was beyond the purview of the captive use. But once it appears that beneficiation is done and it is being done, and it is brought within the purview of the captive use, will they not take an advantage of that? Now I become a captive use. Now they cannot say that the provision relating to a mercantile lease will guide us, but I am entitled to benefit of all captive leases. They have to choose. It's a doctrine of election, what they want. If they chose that I want to come under captive, then they have to come under captive.
That's it. Allow me some time to explain.
Nothing, no further time is required. There's nothing which can be done in this one. Is it too? What is the lease date?
Page 32, your lordship will find. Clause here. Your lordship, of course, there is one more aspect which I have.
Beneficiate, you say beneficiate, word is used. Yes. You say that is not there in the lease deed. I also take it. Please come to page 32, clause 8. Talks about beneficiation. Then it was all along under the beneficiation.
Whether it is mercantile or captive.
Sir, now the beneficiation has come into the captive use.
In 2016.
Earlier it may not be. And you are charging him after 2016. Whatever.
No, Miller.
All the demands are in respect of.
I was supposed to get the benefit of running this lease till 2030. They stopped me in 2020. And from 20, I had signed the deed under protest that it should have been 30. And thereafter, your lordship, I'm in litigation. This is fourth round litigation, your lordship.
Let's see page 323, Miller.
Your lordship, there are two full periods.
Let's see for a moment, let's see kindly turn to page 324. Miller. Fatigue under challenge. 324, Miller. Fatigue under challenge. They applied for an extension, Miller. We extended it up to 2020.
Yes.
They are agreed by that.
According to him, He's entitled to
Up to 2030. Yes, Miller.
if it comes under the purview of the captive.
That is 8A5 Miller. And we have considered it under 8A6 Miller.
That is what the only question is.
If it comes under minor Miller, then rule section 14 will be a bar. Section 14 will be a bar.
What 14?
Section MMDR Act.
14?
Yes.
14. Oh, that says it does not apply to minor minerals.
He cannot take benefit of 8A5.
Yes.
Basically, the executive is arguing against the legislature. And legislature, its own legislative power. Your Lordships, the Supreme Court has clarified this point in a very old judgment of 1986.
Where is it?
Your Lordships. It's para 33.
Which judgment?
Your Lordships, that is D.K. Trivedi and Sons and Others versus State of Gujarat. Para 33, last portion.
Yes.
Your Lordships, may I read from
No, just.
para 33 is that discussion.
53.
33, para 33.
Yeah, probably.
Page 50.
Page 50.
Yes. So in the rules, what they have said.
In rules, they have a transitional provision saying this, that whatever benefit you had got under ATEC, you shall continue to get, provided you were a minor mineral, a major mineral on that date, and you became minor mineral.
Where is that? Oh, that provision is
Yes,
applicable.
yes, you're right.
Oh.
So what this judgment says, gives you benefit to my associate here.
Have you read it? Very interesting. Very interesting. The same provision is the underlying portion. Mr. Das, what reading? And what is that rule?
66.
I'm just highlighting the point so that I will sustain. The point number one.
Lead the usual argument of restitution that from 20 to so many years, 4 times I have gone. Consider, yes, yeah. I'll rest my case on restitution for that prayer.
Let's call the next one.
Well, item 21.
Matter relates to very excess.
My learned staff, the lodges have a hearing on behalf of the opposite party number 4, and the lodges directed me to file my counsel, which I am filing it. So the specters with the entire argument will be not the constitutionality, that's one part. But when this is.
It is not a time for.
That is not their case. There are two things, right? Just to
have
to say.
rejoinder. Copy may be sought to us. No copy.
Copy, you have not. That is the rejoinder.
Mr. Rashid has been sought, sir. It has
No copy is sought to us. There is no about. There is
So it's a question of belief and disbelief. We are not a party to it. You resort.
Let us sort one copy.
You can find online. Yes, ma'am.
I do not know you can settle your this thing.
No, this is my counsel. Yes. Well, actually, this is hopelessly barred by limitation whether mere technicality of the IDs will survive this application.
Today, I believe it's not a choice.
No, just for the assistant record.
We have kept it just for others.
Rather, if I may say so, Lords, I'm actually reducing your Lord's burden to the effect of saying this, Lord. The widest challenge they have hinged to survive the 2001 application, which was rejected in 2008. Two back-to-back laws changed. It was filed in 1990. It is repealed on twice, 2004 and then 2016. Today, he is only challenging the virus of 2016. That's only limited point. And to the effect, whether your lordships will get into the virus of a 2016, when the application 1990, in event when he is to cross the hurdle of a delay. Delay is 2008. He is challenging 2008 the rejection.
Can he not challenge independently the virus of any if it is unconstitutional?
Correct, Lords. Then your lordships will get into the entertainability. My lord will get into the entertainability. It's barred by limitation.
It's a question of virus. The question of relief is a different. But the declaration that the provision is unconstitutional, is there any embargo?
No, then it will be only remaining as not the academy.
So you are different.
I'm only informing before your lordships begin. It's only an academy.
When you give copy.
It's an option.
The copy of the rejoinder. The copy of the rejoinder filed by the commissioner, which is submitted.
In 18 months.
Go on, read the
There's no area left now.
you from reaping the benefit.
Right.
Overlapping area.
So, keep them.
This 22.
Item 22.
Well. The query is for 5 years, my lord.
Counter.
Yes, 5 minutes.
Counter Vijayendra also.
Filed.
Vijayendra. I was granted the query.
Vijayendra is not on record.
It's on record.
Filed
on 11/4.
Is a copy Vijayendra.
Flag D. Flag D.
What is this composite rejoinder means? What do you mean by composite regions?
Because there are three counters on behalf of 1, 3, and 5.
Oh, so you have included everything. Very interesting. Very interesting rejoinder. I have not come across. What is just in nutshell, what is the
Nutshell, short point.
What is the point?
When I was granted a 2-acre plot on a 5-year lease basis, one of the highest bidder, they said it's mentioned in the lease deed, Parvat Kisam 3. Parvat is mountain. Kisam 3. My modified planning plan was also that. After I've operated for a year, then suddenly, my lords, they issue me a letter on 22/3/2024, that is at Annexure 14. They say that no, as per the, even though we have given you the lease and we have done it as per the extent current ROR, for 1988 record, from the SABIC records which is prior to 1980, this may be a Bada Jungle. Chota jungle. Bada jungle. Some
Bada or Chota?
Bada. Bushy forest. So therefore, you are requested to stop immediately, directed to stop. So I stopped operation. Operations were suspended. Then thereafter,
What is the point? That's the fact you are narrating, sir. I'm simply asking the point.
Point is, my lord, now this stop.
Whether it is worth continuing hearing today, that's why I'm asking.
No, it's a short point, can be disposed of.
That is what I wanted to know the point. You are unable to say, tell me the point.
Then, my lord, Annexure 15.
What is the point of law involved? Can you say me?
Now,
That's whether they were within their competence to suspend your on this ground or what point you just
there was a factual survey taken when, my lord, they said that due to the non-availability of the SABIC Naksha, they say on one hand that in the SABIC RORs, you are records, you are Bada Jungle, but then the plots could not be located. SABIC Naksha was not located. Yet, out of presumption, in an assumption, they have stopped my mining operations.
So, according to you, point is whether on the basis of a
Assumption,
assumption or presumption,
can you stop it? And they have not improved their case in the counter. My alternative prayer is, even if you are...
Give me another land, let me go.
What is wrong in that? You have it, you give me another plot and... Well, I'm running up loans, man. I'm running up huge loans and I'm unable to...
Liquidate your loans.
They
will liquidate your loans.
And there's also an element of profit there when you do business. So that is my this is a catch-22 situation. I am now caught between the devil and the deep sea. I don't know where to go.
Malits, here the prayer is only one, Malits. Suspension orders are not under challenge, Malits. The prayer, if I may read here, Malits.
If it is consequential to our main prayer.
No, Malits, what they want in the prayer is modification of the mining plan. For that, Malits, they can approach the authorities. They have not approached the authorities under 22 Rule 7, Malits.
Yes. What you have prayed?
I have prayed for
she is conceding that you go there.
Modifying the existing mining plan.
That is the prayer, Malits.
Modifying the existing mining plan and grant the petitioner the right to carry out quarry operations in the area to the extent of 2 acres out of the 37 acres in the vicinity pertaining to plot number 1622. So this is also covered. My query is also...
Here the issue is after the...
He is agreeing to this. So we are saying that...
If she agrees, I have no difficulty.
Go for a modified plan. In the moment the plan is modified, you can run on that.
No, Malits. Here the issue is after the grant. Here the issue, Malits, is after the grant, it came to the knowledge of the authorities that as per the SABIC record, it was Bada Jungle. So, Malits, as per TN Godavaram, once a jungle, always a jungle, Malits.
But they say that it is Bada Junction.
They say that in Annexure 4, page 100.
Now, what is the law? If there is a conflict between an earlier record of right and a later record of right, which must prevail?
Here, their own the
I'm
notification.
simply asking this question that comes.
Normally, the letter should be, there's a presumption that the letter is correct. Between an earlier ROR and a later ROR, the presumption is always in law that the later ROR is correct.
So how can they rely on an earlier or Sabik means
That-
if I understood,
No.
it is an old or the earlier one.
Precisely for that reason, I have
Because I have come from a state where we call about a CS and RS.
Yes,
CS is a cadastral survey and the RS is the revised survey. So once the revised survey came, cadastral survey that goes.
Precisely for that reason, I filed the latest ROR in Annexure 15.
How can you?
Right after that order, I filed it.
The survey which
Still for Pahada Kiswan.
it must be, I do not know, there the word we uses a bhujar. What is called bhujar?
Here also, Puja.
Bhujar.
Page 125, the latest ROR says it is for what?
There, the Shamiana and the Tambu was there in the open, the field and then inviting everybody to come.
Yes, the same everywhere.
Everywhere, yeah.
Yes.
Same
May
thing.
not exactly be a tambu, but a small house. It's taken in a
It
village.
was a tambu.
It was camp course.
Settlement camps in Cancun.
Page
Page 125.
If there is a conflict, which
Page 125, your latest ROR is there.
Rely upon counter affidavit annexes.
I am talking about the proposition of law.
Yes, Manoj.
Sabik means old, if I understood. Hal means the current.
It's current.
Correct? So when there is a conflict between a Sabik and a Hal, then which is more reliable, which the court will believe? Which will prevail over other?
So all these have been carved out as author one.
Yes, your lordship find that at page 125, your lordship finds my plot number at the last one. 111616 or 88. Sonda Parva.
Basing on that only you have been allowed the.
Yes, that is the
That-
that was by grant also.
That is not disputed that as per HAL record only it was per birth and accordingly it was auctioned and it was given on lease to the petitioner Malad. But subsequently when it was found out that it as per Sabik it was Bada Jangal and
Who found out and the manner in which you found out? Who found out?
That is vague. That has not been. No details, nothing.
The manner in which you had to go for the inquiry and all that.
Counter
Was the lease
spells out
granted?
nothing.
Was there any objections? Let's say Patra Jungle or Bada Jungle, how the mining activities is being taken off?
Pilots in the counter affidavit, we have mentioned that the Tehsildar had done a verification, my lord. The basis might be, my lord, Annexure C by 5, page number 16 of counter affidavit filed by 1, 3 and 5, my lords, which talks about change of classification of land in record of rights. What is required was forest clearance, my lords.
No, change of classification.
I'm just.
Here also the provision of-
Judgment of the Calcutta High Court, I know.
They have given the provision of law in the counter also.
Against it. Two judgments kindly consider
Section
it.
13(3).
It down. This is a All India Reporter AIR 1981, Calcutta, page 74. And AIR 1978, Calcutta, page 556. Conflict between the earlier record of rights and the revised record of right or a subsequent record of right, which must prevail before the court, eye of law.
Section 13(3) of the Odisha Survey Settlement Act, the later ROR. That they have this is
That
mentioned.
is what in those judgments also held. That is what I am giving it to.
Well,
However, my lords, those orders are not under children in the present writ petition, my lords. The only limited prayer is modification. And as per my lords, if I may.
So only prayer is, so I will allow all the prayer
in toto what they have prayed for.
If I may
No difficulty.
My lords, if I may refer to P. N. Godavaram judgment. what is
Yes,
the
we will
meaning-
consider it. T.N. Godavaran, we have been considering in many of the cases. We will again consider it.
Yes, ma'am.
But the point is something different. Yeah, T.N. Godavaran. Mining in a forest area, we will see to.
I draw your lordship's attention for a second to their own annexure C5, one line. As per the provisions of under section 13(3) of the Orissa Settlement Act 1958, if any entry in the RORs is altered in subsequent ROR, the later has to be presumed to be correct until proved by evidence to be incorrect, but the previous entry can be admissible as evidence of the fact existing at the time such a decision was made.
This was in relation to a forest. So now it was in relation to a pala. Yes.
And in the same annexure, it further reads that in case required for a project, the status of the land classified as forest on 2510.
If it is so, what prevented you not to allow him to have another part of
For that, my lords,
mining plan that he is seeking for?
for that prayer, my lords, for that effect, I was referring to Rule 22(7), my lord, which reads that holder of a prospecting license or mining lease or mining lease desirous of seeking modification in the approved mining plan or scheme of mining as are considered expedient in the interest of safe.
Now, it is a question of this modification in a mining plan means that how much quantity he may be permitted within a particular leased area to be extracted. He wanted the quantity to be extracted, varied, increase, decrease, whatever, that is all depending upon that. Now the question here, you have suspended the operation. You say that it comes within the purview of the forest. But at the time, that too on the basis of the previous record of right.
Previous record of right.
In a subsequent record of right, it is not recorded.
It's recorded.
If that is not recorded, then the question would be, can you rely upon an earlier over the latest one? That is what a question. If you cannot, the presumption of correctness lies with the latter one, then your decision is wrong. There may be a multiple factor. There was a forest, but because of the urbanization, erosion, there is already many things, natural calamities may happen. It has gradually been diminished. Natural calamities.
Then also.
There are many things.
Then also.
So it may
convert
into this. It may convert into this.
Then also, as per Forest Conservation Act, approval from the competent ministry is required under Section 2 of the Forest Conservation Act.
That is why I do not know when this the revised settlement, I mean the R1 came, what was the law at that point of time? How the record of rights were changed? What the authorities have done? They must have taken everything on steps. Otherwise, they will not alter the record or make a new entry without any corroborating document. So that presumption of correctness has to be understood. Again, I am reminded of AI 1954 Calcutta. Presumption of the correctness of the entry is always there, unless rebutted by a very convincing evidence.
I bow down to that.
Can't be
The
done.
only effect here is because it is a forest, my lord.
So
And
you can't feel that too.
my lords, as per T.N. Godavaram case, my lords. And
You say that if it has converted, the present situation does not permit, then
Not a case of conversion.
my lords, here is not a case, but as once upon a time, it was forest. And
why you granted?
Yeah.
It is there's comma, why you granted?
at that point of time.
And now the situation is just reversed, there is no forest. Keeping this matter.
We'll let it come next week, my lords. I will examine, my lords, these judgments also. Examine these judgments.
Said that's why I wanted to go through those line of judgments. Yes.
Item number 23.
Please, Lordship, my lord, here we are submitting the rejoinder affidavit as for the last one.
copy given.
Well, just now they have given a copy.
That the inverter right by the minister be taken on record. Copy thereof has been served upon the
You have filed one additional affidavit with certain document like IBM document. I've sought a copy, it might not have come on my lord's record. So. Next. Next to next.
you have taken this fight.
Definitely 1 week after Lordship has posted to next week.
Next.
Item 20, 1 week after.
Yes, ma'am. Item 25.
State has to find a counter affidavit.
Lord, actually, this matter has become infectious and it has become academic. Lord. First, Lord, the case of the petitioner was whether security money is to be deposited by cash or by bank guarantee.
You have included cash.
In the meantime, he has deposited in cash and that is accepted.
Madam, then what remains? Your senior has not told you.
My senior has told me that there is a law point. There
is a law point involved.
Yes.
There is no law point involved. Still, the client is in contact with him.
Yes.
Still. That is a very vital point in this. Adjournment.
Item 26.
26, my lord, the issue is covered by your lordship. When the lessee has not removed the sand, when the lessee has not removed the sand, whether he is liable to pay the royalty and the additional.
That is what the incident of charging the royalty does not arise.
In that case is different. In that case, for example, the lease deed was executed prior to execution.
I am simply asking, is it the case where you are charging the royalty when he has not removed the mineral from the site?
That is true.
True.
You were charging because he has
And
not.
are you aware of our judgment?
Yes, ma'am.
Are you aware
Yes.
of Dili Meher's judgment?
These are yes.
Dili Meher.
Yes.
Are you aware?
Yes.
So we have heard that incident of charging the royalty is conspicuously absent.
Here the difference is in the present case, lease is granted 2020, and thereafter he could not operate it because of his own lacuna, and therefore, but in the present.
You can charge a dead rent, you can charge DMF, whatever you want to charge. But royalty is an incident, then that minor minerals, that the judgment of 9 judgment, it says that what is the incident of charging the royalty? When the mineral is removed from the mining area, then it becomes chargeable. He has not removed, he has not operated, whatever you.
Here the ground is the course of the river changed, man.
Our case is that when
He has voluntarily not extracted.
minimum guaranteed quota, he has to pay the royalty.
Then impose a penalty.
That is what we are doing. That is
No,
what we are
royalty. There is a difficulty. The penalty and the royalty are two different concepts.
That royalty is not.
What are you talking about?
That the royalty means that is a penalty.
No,
royalty is not a penalty.
Fine. I have to, that all of us have to.
That he has to
No,
penalty.
No.
it's a very dangerous submission. The royalty is a penalty.
That is the rule, sir. That is the rule.
No, sir, never.
Yes, sir. So you can see my countenance.
No,
That we say he has to pay each year.
whatever we say under the act, that it does not come.
Then he has to challenge the rules itself.
Yes.
Then he has to challenge the
Rule
rule.
32 proviso to Rule 32 subsection 2.
Yes.
In that
What it
judgment
says.
it says provided further where the lessee becomes liable for payment of royalty for any minor mineral removed or consumed by him.
So that is what is there, remove or consume. You have not removed nor you have consumed. So that is what he also said.
In that judgment.
Here also can say I'm pressing the rules.
Nothing rules.
Rules
Yes.
specifically say that he has to pay the royalty in advance, one year in advance, and thereafter he is to operational. He has not deposited the royalty amount or other amount he has not deposited, but due to his own fault. Yeah?
He is not running.
He is running.
No,
No, he is not running because
So where from his position?
he could not obtain the history
You
environment.
can cancel the lease, you can do whatever.
Already
you
That
want.
was cancelled. We have cancelled, but we have demanded the which he should have deposited. He has not deposited. That is what we have.
The first advance certificate.
But the
Two, three. No,
bill delivered.
no, you will also place the rules. No,
So we have.
the transfer affidavit specifically stated it is a clear violation of the rules.
Correct.
And we are charging person to the rules because he has to pay
You
in
see
advance.
counter affidavit you have filed?
Yes,
Yes, you will see.
and your lordship's case, in that case, lease deed was
There
not.
was no case. I have no.
No, in that case, your lordship judgment.
You say your lordship's case, I was shocked.
In that case, lease deed was not executed prior to that. Yes.
Don't go by your letter.
Prior to that,
Go by your ratio of the
Prior to
judgment.
that was charged.
Unless for first year I have deposited lease deed.
Prior to that was charged. Without any lease deed, royalty has been charged.
In that case, there was a lease deed. In our case, there is also a lease deed.
No, lease deed prior.
Every judgment is distinguishable on hands.
The lease deed is only executed after I pay the royalty.
Ratio of the judgment which is the. Yes, takes great.
Yes, sir. Second case accomplished that. Both the cases.
Let's keep it for.
Item number 27.
So this covered by your lordship.
But this matter will file counter affidavit. That's it. To follow this.
Maybe not
Covered by.
Robert, 51 and 58, lordship has already interpreted lot, and I have annexed those judgments.
Which?
51 and, yes, 51 and 58 rules of OMNC rules, madam. And since 1 year my vehicle is standing, madam, for a truckload of sand, madam. They have impounded my vehicle, madam. Imposed penalty of 2 lakh. Two judgments, madam. That is annexes 3 and 4.
Yes, how can you?
That's my column is to make tomorrow.
Tomorrow. Will dispose of. Next.
No, the heading of fresh admission, madam, we take for you. Look, since 1 year my truck for.
Oh, tomorrow, we are keeping this matter tomorrow as to be mentioned.
Nice. Item 28.
Notes. I will be rejoined us today and sending a copy.
That tomorrow. Representative in the state, who is your representative? What do you want? Next week?
One is after.
No, next week. Okay, well, the representative is. So.
29 millets are directed for counter to be filed. We require some more time, 2 weeks time.
First extension.
First extension. Yes.
One week, we joined the 3 weeks.
Item 30.
Is there?
The 20% deviation in the mining plan, whether it would include the EC or not.
20%.
Whether EC will prevail over here.
MP or whether it applies.
Yes. But here is a case when subsequently we have filed the counter affidavit that they have extracted within the mining plan limit, but in violation of the EC.
Yes.
No, that is
So
what
that
I'm saying.
20% clause which they want to invoke, that is not at all the issue here. That is what the grounds which was taken before the revisional authority. That is not at all the ground.
Yes, the ground it is there. Reading it is there. No, I have seen, that's why.
Yes, grounds they have
You are
taken,
not arguing
but that is not an issue.
I pointed the. You have to formulate in the order itself. Anything more to say? Well, they are actually, if Lordship read the judgment itself, it is very applicable to our cases. Your Lordship has referred to paragraph 118. That's a common cause judgment. Yes. And now let us go through the common cause judgment. Yes. I just wanted any other judgment which has come. No. Thereafter, actually, I checked up. No. Any other judgment here, anything is said, it involves the last one is a common cause. Yes, sir. No, I wanted to know whether judgment has come or not. It has not come. We are muted. If you are that,
but only in the counter affidavit, CAV. And in the counter affidavit, we have specifically said that 20%.
Oh, we will consider it. When you have taken a point, we will definitely see.
There is no deviation of 20%.
If it does not apply, it does not apply. Yes, we have filed a rejoinder. They have admitted otherwise. There is no violation of EC. No violation
of mining plan, but there is a violation of EC.
No,
that we have said.
So
that we have said categorically in the counter.
I'll just indicate.
Item 31.
Last year, after July, the enhancement was done in EC. Pro rata was not applicable prior to that. That is the catch, in fact.
Pro rata, Supreme Court judgment in 2007.
Formula is given, I have seen that. Yes. Yes.
31.
31 and 32. The lease deeds, I have procured the lease deed in the meantime. The old one by the ex-lessee and the new one. So I want to put those documents on record by weapon affidavit.
But tomorrow can I give a short note, my lord, that indicating that other one, previous one. Give it. Yes, you want to give it. I don't. But
31.
31, 32, I pray one is.
So let me come next week. Senior counsel is next week.
31 and 32.
Is there in the other one? 31, 32.
Item 33.
33 is better.
I'm acting on behalf of Mr. PC last.
What do you want?
Again? One week time. To fight
Next week.
Item 34.
We are just preparing the counter affidavit. It will be filed by tomorrow and copied by tomorrow.
It's submitted by.
This one.
In the event, the clerk on a
35.
35th, filed a counter on 12th, my lord. I seek 2 weeks time to file rejoinder. In the meantime, let them serve another copy because annexes are not visible of the counter. The submitted that though the copy of the counter affidavit is served. Thirty-six is the tax deducted at source.
36 by virtual option entered in direction amount has already been deposited and is now in the bank in fixed deposit.
Now the batch of cases relating to the subject matter is fixed to 25th. It's not fixed on 25th, it can be decided.
This is the compass with ISB.
The batch will fix on.
Item 37.
26.
37, sir.
27.
It's when I am appearing for the opposite party, I take too much time to file something.
Last extension or?
First time is first appealing for the first time after the negative being served.
Thanks, Doctor, affidavit by 2 weeks. You are appealing for?
For opposite party number 1.
Yes. Let it come on 1st September also there, no?
Yes. 1 week rejoinder.
Let it come on 1st September, your lordship. Because short matter, I may not have to file the rejoinder.
3 days rejoinder.
Lordship.
3 days rejoinder.
Next. Item 38.
Your lordship, I'm appealing for the petitioner.
I'm appealing for the OP number 1.
This has been served, your lordship. They are appealing for the first day.
Yes, ma'am. Too much time may be entered to filing counter.
Doctor, rejoinder 1 week.
Lordship.
That's okay after this.
Item number 39.
Can your lordship kindly see last order 4/8/26, my lord? Your lordship directed to file counter. And they undertake. One government order undertake to file counter on 4/8 in course of the day for implementing order, my lord. Despite the nature filing counter, your lordship kindly see. My lead will going to over 4/8/26 ordinance.
For that, subject will not come. Volume.
My lord, twice on 2 occasions, your lordship directed. On 28/7 and 4/8.
Yes, where is the
Counter affidavit is already affirmed. I'm serving a copy.
On that day, in course of the
Yes, yes, it was affirmed on that day. Could not be filed.
You are keeping in the next week.
Yes.
In the meantime, if you show this, you can file a rejoinder. Well, today.
My lord, on behalf of the petitioner, my lord, may be taken up after 2 weeks for final hearing.
2 weeks.
Item 41. 8.
Yes, they will give you.
Item 41. Item 42.
Yes, 42 years. I just want to challenge you. The counter appearance file and I also filed the rejoinder.
Also, it appears that
those have not been brought into record lot. So counter rejoinder are already filed. Appears in short. May the liquid matter lot may take. I'm appealing one of the petitioning agreement.
it should come on the record.
Yes, ma'am. Item 43.
If we pay attention, month of September at which may be fixed. Because entire next week is started all hearing matters.
Kindly fix it for 8th if possible. And lots of some precedence.
8th September.
Tuesday.
8th is Tuesday, today is Tuesday. And lots of some precedence.
At 3:30.
3:30.
On 8.
2:30 lots of.
3:30.
3:30, another matter.
No, that is
Next is.
Then.
Yes, here you were in the morning, we can inform you.
Yeah, Lord, I was coming and but at the nick of time I could not meet with the.
So I was waiting at least for 5 minutes. We just waited for you. You did not come.
Dear Lord, when the matter going on to serial number 2, I also present for this court and
I did not notice because I was involved in this other. Then come on the other day, we will hear you
I did hear.
on a proposition of law.
Next week.
Next week.
Next week.
Next week. Lordship passes an order. We have passed an order.
Yes, ma'am.